I call this regularly scheduled meeting of the Tennessee Real Estate Appraiser Commission to order. At this time, I would like to have a roll call beginning to my right with Ms. Johnson. If you'd signify your name and where you're from, please.
Rosie Johnson, Paris.
Randall Thomas, Kingsport.
Fred McCara, Johnson City.
Eric Collinsworth, Arrington.
Tim Walton, Collierville.
Mark Johnstone, Jackson.
Norman Hall, Brentwood, Tennessee.
Nancy Point, Rogersville.
Okay, thank you. That does constitute a quorum to conduct business on behalf of this commission. At this time, I would entertain a motion to adopt the agenda.
So move.
Second.
All right. Motion by Commissioner Hall, seconded by Commissioner Thomas. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Agenda adopted. This regularly scheduled commission meeting is taking place in room 1B of the David Crockett Tower, 500 James Robinson Parkway, Nashville, Tennessee. And notice of this meeting was posted on the Tennessee Real Estate Appraisal Commission website. This time, we will entertain a motion for approval of the April minutes.
So moved.
Second.
A motion from Commissioner Collinsworth, seconded by Commissioner Hall, for approval of the April minutes. Are there any discussions or adjustments to those minutes? If not, all in favor signify by saying aye.
Aye.
Any opposed? April minutes are approved. A report of experience interviews and recommendations. At this time, we'll have our experience reports.
Do I also need to discuss the three that we had back at the April, or between the April and June? I had three interviews that I conducted between the April meeting and today's meeting as well. They were with Stanton Eugene Allen, Mark Allen Walden, and Anthony Glenn Samples. And based on my information from what I reviewed and their interview process, my vote, my recommendation at that point in time was to approve two of those. One of them at the time, and I see now that two of those since then have already submitted their exam. So again, my recommendation was to approve on those. I also this morning spoke with Heather Ann Coleman, who's requesting to move from trainee to licensee or licensed appraiser. My vote on that one is to approve. My recommendation is to approve her as well. And then the last one's Jessica Dale Bishop. She has recently gotten married. It was Jessica Patterson on the reports that I reviewed. She's requesting trainee to certified residential. She has also now taken her exam. I found out this morning it says no in our agenda, but she has also passed the exam. And my recommendation for Ms. Bishop is also to approve.
Okay, I have, my list is gone, so I've tried to write these names down.
Sure.
I'm cheating off of Commissioner Hall here. I understand you made approval for all four of those?
All five, yes, sir.
Or five, okay. Can you repeat those names one more time, please, sir?
Yes, Stanton Eugene Allen,
Right.
Mark Allen Walden, Anthony Glenn Samples, Heather Ann Coleman, and it is now Jessica Dale Bishop. There's Patterson on the reports I reviewed, but it's Jessica Dale Bishop.
Thank you for that report, sir. You've heard the recommendation from, at this time, I would entertain a motion to approve the committee recommendation for the experience.
So moved.
Commissioner Walden has made a recommendation to approve of these five. Is there a second?
A second.
Seconded by Commissioner Point. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Experience approved. Next. Mr. Hall?
Yes, sir. I was asked to interview Mr. Terrence John Peacock. properties which he had appraised. One was in Cleveland, Tennessee. '64, 1965, and part of 1966. I was able to check him very well on whether or not he knew about Cleveland, Tennessee. Other two properties were also reviewed with him. But based on that, he still has not taken his exam yet for certified general, and of course, prove his experience right now for certified general.
Thank you, Mr. Hall, for that report. You've heard the committee recommendation for approval of Mr. Peacock's experience. Do I have a motion to that effect?
So moved.
Second.
Okay, motion from Commissioner Thomas, seconded by Commissioner Johnson. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Experience approved. Thank you, Commissioner Hall. Commissioner Point.
I interviewed Jared Smith and found his work to be complete. And it would recommend that we approve him to move from certified residential to certified general.
You've heard the committee recommendation for approval of Mr. Smith's experience. Do we have a motion to that effect?
So move.
Commissioner Hall, seconded by
I'll
Commissioner
second. Yeah.
Thomas. Any discussion?
Collinsworth.
Collinsworth, excuse me. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, a recommendation approved. I think that concludes the experience interviews. This time, we're ready for the education report.
We had 29 applications, 19 for regular courses and 10 individual course applications. All the applications for regular courses were continuing education, and I recommend approval of all 19 of the courses and approval of the 10 individual course applications.
Okay, you've heard the report of the Education Committee with the recommendations from the chair. Do we have a motion to adopt the committee recommendation?
So moved.
Second.
Commissioner Walton moves to approve. Commissioner Hall seconds that. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, recommendation approved. Before we go to the director's report, I want to make one announcement from the chair. We have, there was a sign-in list that everybody had when they first arrived. There's also, I have asked Director Avers to put another list out there for individuals that would like to speak in the afternoon session and as to what topic they would like to speak to, so we can get an idea of how many speakers we have and how much time that we have. So you can do it at the break, at your leisure, at lunch, whenever, but if you would please kindly sign that if you intend to speak to the commission after lunch. Director Avers, you are recognized.
I have updated the budget and year-to-date information for revenue and expenditures for the commission's review. I have also updated the license counts as of June 23rd, 2015. Currently, there are 810 certified generals, 962 certified residentials, and 116 licensed real estate appraisers, and 189 registered trainees. There are 160 appraisal management companies. As of that date, we also had 149 active temporary permits and 385 active approved courses. The complaint information, so that you have the 20,000 foot view of our complaint status. We had 10 complaints in payment plan tracking, which means they had either incomplete education, experience logs, or civil penalties due. We have 4 matters that are scheduled for formal hearing. We had 15 that were ready for the legal report, and 7 matters that were under review. There are no legislative updates for this month. The first item that I have for the commission members' vote is that there will be another Aero Conference, October 16th through 20th in Washington, D.C. I thank you all for participating in the spring conference here in Nashville. I would like the board to vote on approval of sending 2 of its board members and the director and board council to attend the fall conference. For the board council, I would like that to be the litigation council because Ms. Baird will be unavailable, unfortunately. So if the board could decide which 2 board members will be attending the Fall Aero Conference and vote on that matter, that would be terrific. Because we want to get the travel approval as early as possible.
In the past, we've generally sent the chairman and the vice chair, or tried to send somebody, or either a AMC director member.
I would like to nominate the chairman and the vice chair as our 2 selected attendees,
Maybe we should.
if they are available.
Maybe
on
we
those
should
dates.
defer and do the nominations for chair and vice chair.
Well, we can do, it's that point.
Okay.
Oh, I see what you're saying, because it will be new.
Yeah, at this time, that might be, if it's okay with this body, that might be a good thing to do, is to go on and nominate the chair and the vice chair at this time going into next year, because if we're going to approve that and there's a conflict, it'd be better to get it out on the table now.
Okay.
Okay?
Mr.
At this
Chairman?
time, I'd entertain,
Mr. Chairman,
yes,
I would like to recommend Mr. Tim Walton for chairman for next year, and Mr. Gary Standiford to be the vice chair.
I'll second that.
okay. You heard a motion and a second for the chair and vice chair, beginning at the next meeting. Can you? All in favor signify by saying aye.
Aye.
Any opposed? Congratulations, Commissioner Walton,
Thank you.
and congratulations
That was fast.
to Mr. Staniford, who's not here.
Accept.
So it
but
happens when
Now
you
I
miss
would
a
like to
meeting.
nominate the chairman and the vice chairman as the attendees. Now, I know Mr. Standiford did go last year, so I don't know if the board wants to send somebody new,
Well,
or if we would still.
If Mr. Staniford wants to bow out and let someone else go in his place, he could certainly let Ms. Avers know, and then he can choose someone to attend in his spot.
If I may, contrary to public opinion, I would suggest that Mr. Walton talk with who will be his cohort to find out whether or not he would be available. And if he can't, then they can tell us, hey, he can't go. Who do you think ought to go? I know sometimes we catch a lot of flack because we try to get things cleaned up outside of sitting here in front of you guys, or you ladies, and I feel that we need to do that. So consequently, I would like to suggest that Mr. Walton and also Mr. Standiford discuss whether they can or can't go, and if they can't, let us know, we'll move forward.
All right, do we have a motion on the floor for the chair and the vice chair? And it was made by, who made that? Was there a second on that?
Yes.
Commissioner Hall? Any other discussion? If not,
Does that recommendation include the director and the attorney?
no, it does not. So we'll have to. Well, we'll take
And I
that.
thought it was understood that you guys.
Why don't
would
we
be
vote
going.
on this one, and then we'll do the director and the attorney separate, unless we want to make unless you want to amend this one.
Well, if Mr.
I mean, I'm
Hall
trying to
will
keep it
retract
clean.
his-
If we're gonna,
Yeah.
Oh, we can keep it where it is and just add one more.
okay, let's,
Friendly amendment?
okay, would you?
I will
would you-
amend to add not only the chairman and the vice chairman elect, but also Director Avers, and then the litigating
Chick.
attorney, okay.
That was an amendment. Would you accept that as a friendly amendment?
Yes.
Okay. Any other discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, thank you. And at this time, I do want to mention Mr. Standiford. I had spoke with him this morning, and he had asked for us to keep him in his prayers. He's undergoing some health issues at this time, and we should hopefully hear some good news in the next day or two. So, all right, we're still under director's report.
One item not listed is I've heard some good news that Mr. Johnstone and Ms. Johnson have agreed to serve another 3 years on the board. I thought I should share that with everybody. Yay! So that was off book, but it was subsequent to my compiling of the director's report. A little bit of crazy to add. As of June, I officially became the director over 17 programs in regulatory boards. This change came with an increased staff and several new programs to the Division of Regulatory Boards. If you want to see something humorous, try to get me to list all 17 of them. This does not change my commitment to the appraisal profession and will not diminish the resources available to the board. However, as I learn these new programs and get several new initiatives underway, please have patience with my time. So I just wanted to let you all know that there's a lot of new information that me and my staff are absorbing all at once, and we've had to do a bit of scrambling to get these new programs underway. Some of them came from consumer. One that was entirely out of commerce and insurance, which was court reporters, came from the office. Administrative office of the court. Court reporters is also another program.
What reporters do we have in the state of Tennessee?
517. Should be 518 as of this week. Because we needed. So, lots of new challenges, but I wanted you all to be aware. The board has a new website. At your convenience, please take a moment to check out some of the new features of the website. It is hoped the new design will be more user-friendly for the consumers and the licensees and present a consistent image throughout the state of Tennessee's various departments. It's not just our website that got updated, it's the entire state of Tennessee's websites. So, beginning in September, a new licensing system is going live. There will be a brief period during the first 10 days of September where there's going to be a transition from one licensing database to another. It's recommended to all licensees that have an expiration during that window that they renew early so there's no delay in getting your license. There has been a media announcement sent out with the renewal forms, and we will be sending out additional information as we get closer to the time of the transition to remind people to renew a little early. That 10-day period where essentially we will not be able to do anything to their license.
That's assuming that any appraisers would wait to the last minute.
Right, nobody ever does that, so. We have an additional policy recommendation based on the experience interviews that Mr. Collinsworth has very, very kindly been handling in the 2 months since we last met. We recommend an applicant may be granted a credential once it has been determined by the Administrative Office of the Real Estate Appraiser Commission that all education requirements are completed, an experience review has been completed by a commissioner and documented to the file, and the examination pass certificate has been submitted to the Administrative Office. A report of experience interviews and any upgrades will be provided at each board meeting. We just add that as an additional policy. Rather than keeping someone waiting to complete their upgrade during the two month or 3 month window between board meetings, which just seems unduly professional, waiting to get their credential. If one of you come into our office, interview them, find their experience valid, if you can just, as we've been forward, we recommend this being the policy moving forward, if you all can agree to it.
What you've heard is a Policy 11 recommendation from the staff. At this time, what's the thoughts for this board? I'd like to open it up for discussion of this body.
Just for clarification, saying that somebody does not have to come before this commission anymore?
No.
I just don't understand.
We review their application. A commission member does their experience interview, and we have to get their exam certificate. If, like, Mr. Collinsworth or you do their experience interview between the board meetings, I don't think the applicant should have to wait till the next board meeting for the whole board to vote on it.
So theoretically, if as an appraiser who lives in Memphis or lives in Bristol,
If that's how the
I'm
commission wants to
just
set
trying
it
to
up,
understand. I'm just
I
trying to
would
think
still.
it's-
It would still have to be done through the commission office here, arrange it.
As I understand this and read it, what the exercise that we just went through momentarily ago about having someone interview them and then make a recommendation of this body will cease to exist. It will be done between the staff and one commissioner, regardless of where they live, and the rest of this body will have no say-so in experience. That's what this does.
It's just a proposal, so it can be voted up or down.
And it's pretty much in the off-month meetings. I mean, off-meeting months. So we're not having a meeting in August and somebody submits for their interview, the proposal basically says, okay, somebody from this commission could go ahead and do the interview in August, for example, or whenever it's scheduled through the commission. And then if all requirements are met, then they would have the ability, the commission would have the administrative office would have the ability to go ahead and approve that.
Mr. Chairman, question.
I recognize, sir.
Historically speaking, has that been a big issue that someone has been recommended by a commissioner and the rest of the commission has voted in the opposite direction?
I've never seen it happen.
No, it has not been an issue.
I don't see why it should be an issue to, I think this is, I'm speaking in favor of this
It's
recommendation.
more, well, from my understanding, I'll let Mr. Hall speak. I don't think there is an issue in terms of that, but what I've seen over the last 3 years is this board is becoming so much streamlined that the board really has little authority, and the staff and the administrative officers are doing everything. And so it just seems like we're turning over control. Not that that's inherently bad if that's what we want to do, but I just want to make sure that as we vote on these recommendations, do we understand the ramifications of what they are to this body? Mr. Hall.
my concern is all of a sudden we're able to have knowledge to make decisions. Will we be making the right decision? And where I'm going with this is we're going to have some hearings coming up very shortly. I don't have a clue what anybody's talking about. I don't know where the prompt is located. I don't know who the people are or anything about it. And I'm going to be asked to make a decision. So what I'm hearing there is if somebody comes up, let's just say in the Middle Tennessee area, and I used to know everybody. I don't know anybody now. But if I know these people, and I know for a fact, I don't give a flip who they are, what they are, they're not very good. And therefore, they should not be approved. Am I going to be told, forget it, you can't judge them based on what you know? You're going to have to look at that report and then make a decision. I'm just concerned that the board here needs to make sure that we are not automatically either approving or
I think the general purpose behind their thought in this whole process, the reason we're suggesting, I think, to do this now maybe is because we're going to possibly every other month or maybe even every third month to meet, where in the past we've met on a monthly basis. So this has never been a reason to discuss this before. But if you were a trainee and you wanted to sit for your exam to be upgraded to a certified residential appraiser tomorrow, if we're not meeting until September, do you think it would be fair to have to wait until the September meeting to be able to hear the board approve and go through the same process versus the commission, the administrative office, being able to set up a meeting with a commissioner to hold the experience level interview, say the first week of August, get that approved, get it out of the way, and if that commissioner who holds the interview feels that it's appropriate to approve, just like we did this morning, do you feel it's fair that you make them wait until September and vote on it at that point? I think that's the general idea behind this recommendation, is because of the fact that we're going to a every other month or possibly even every third month meeting, streamline the process so it's not unfair to them to make them wait.
I don't think it's a situation of being unfair to anybody. I think it's a question of being fair to the public who engages our services. And at this point in time, what this commission has done, we've had the individuals who have applied to be interviewed by someone, in all probability, not from the same area where they're located, who does not know them, not familiar with them, and has to gain it, at least review their work product. To me, that's far more important. Sorry, I just feel that we need to make sure that we know what's going on, but we talk to this individual, we find out what's going on. I can tell you right now, tell this commission and tell the people here, if we move this thing up to the point where we don't have to have interviews except when we want to, i.e., tell me, give me a name. Don't even bother to bring me a report. I'll probably know the person. I can tell you right now whether it'll be good or bad. I can tell you that right now. I don't have to read USPAP. I don't have to read all of this stuff. I know that individual. I know what that reputation is. And I'll make a decision right on the spot about what they do. Is that what we want to move to? Or do we want to have...
What if we were to make the recommendation based on the administrative office setting up the interview with the most locationally available commission member? In other words, as you mentioned earlier, if it's up in Bristol, then they try to set it up with Commissioner Thomas or Commissioner Point. If it's in Memphis, they try to set it up with Commissioner Walton or Commissioner Johnstone, so that they are more locationally adept in the product that they're going to be reviewing. Will that meet your thought pattern there, Commissioner Hall?
My concern there is the fact that right now we have matters brought before this commission to discuss individuals whose work product has been given to this commission and whom has been sent to somebody to review that report to see whether or not it is or is not in accordance with USPAP. I often wonder whether or not that is an efficient way to do things when we're asked here as a commission to make judgment on cases and we don't have a clue who it is, where the property is, what's going, we know nothing about it, but yet we asked to make a decision based on somebody who read a report somewhere. To me, I have a real problem with that. If you can't tell me who it is, where it is, and you're asking me to make a decision, I got a problem. So if we want to change this so that now we'll just send an individual out to somebody and let that person do it, I think I just don't like that idea.
Mr. Chair?
Yeah.
Commissioner Avers, you're recognized.
I think Mr. Hall is confusing the question of experience interviews with complaints, because you seem to be discussing the complaint process with the experience interview process. The anonymity of the complaint process is where we preserve the names of the individuals, the trainees. We don't withhold names or locations of trainees.
No, but the problem is, we get where the commission's staff have reviewed appraisal reports, and then we're told that we just had a complaint filed on that individual, and the
We're-
only thing they've done so far is made application to become a member.
We don't, this policy recommendation has nothing to do with administrative staff reviewing anyone's experience. This policy still upholds the commission members reviewing experience. The only thing we review is their education and their exam results,
What you're doing now.
which is what we currently
Never
do and
review-
we've done
you never
historically.
review.
Hold on, let's take it one person at a time on the floor, and at this time, Commissioner Hall has the floor. If you'll let the chair be known, I'll recognize you appropriately.
It's my understanding you review an appraisal, correct?
I review no one's experience.
You review an appraisal, is that correct?
That is incorrect.
Well, how do you file a complaint against them if you don't look at the appraisal?
Again, I am telling you, you're confusing the complaint with the experience reviews.
Okay, so tell me something. What am I going to look at to find out what experience they've got? What am I going to look at?
Mr. Chair, do you want me to continue?
I think what Mr. Hall was alluding to was at the end of last year when we had, I think the staff did review some reports to ease the pressure off of us. I think that may be what he was alluding to. And some of those, I think, did get turned in.
In October and November, at the commission's request, I reviewed some reports, and there were some very low-quality reports submitted at the end of last year. I have not reviewed anyone's reports since then, and all of those reports were additionally reviewed by expert witnesses.
Is when you review an appraisal,
Not reviewing anyone's appraisals.
how are you going to come up with that experience then? What are you going to look at to judge somebody's experience?
I don't judge anyone's experience. We have experience logs, we select the reports at random, and then the commission members review their experience. I don't want to review experience. I have 17 programs I oversee. I don't have time to review everyone's experience.
I think what we're talking about here, in the past, we did give some temporary authority to the director to look at some reports when we were making that transition period of new licensees. This, as I understand this recommendation, she will still call a commission member to do the experience review. And they'll do it, I don't know where they'll do it. I think the locational issue can be somewhat problematic because the complexity of the assignment. If you have somebody for a CG and you've got two residential appraisers in East Tennessee and they're from East Tennessee, then that's going to be an issue, and we always kind of have those, but as we meet here, that nullifies that problem. I think Commissioner Hall has a valid point in if they're sending it to West Tennessee, and I'm the one reviewing that, and I know that person or don't know that person, I may just choose to go one way or another and not even spend a lot of quality time on it. Or you may be forced or in an uncomfortable situation where if you don't agree, then you're going to have repercussions from that if you do. So I can see both sides of where he's coming from on this. Commissioner Hall, you're recognized, and then Mr. Walton has a
I
question.
reckon my concern is, and help me out, okay? Now, this complaint was filed by the administrative staff of the Tennessee Real Estate Appraisals Commission as a result of a trainee experience interview. This matter concerns the supervision and trainee in 3 residential appraisals indicated by the reviewing board member. You're not reviewing his experience, right? But yet you've got a review here to do.
Mr. Hall, that was before the end of the year. We had an upsurge of people trying to apply to upgrade. When we had the 2015 changes coming in, I have not reviewed anyone's experience since before the end of the beginning of the year.
Is
And
it-
you're talking about the complaint report instead of the director's report.
I understand that, and that, as a point of information and clarification, that's what I was alluding to, was when we had that trainee rollover at the end of the year, and we'd given her permission to review some of the residentials to release the burden on us, and I think some of those did get turned in, and that was one of the ones he's alluding to. I think since that has happened, they have not been reviewing any,
I think he's in the legal report.
well, he is in the
I
legal
am.
report, but
This
he
is-
was drawing a
this is on
parallel
July.
from that.
Right, this is
back in-
July the 13th, 2015. It's the one to be heard today.
But we're not at this point yet.
We're not
We're,
in the legal.
No,
but
we're
but
not
he's using
there.
that as a parallel, I think, between changing a policy here, which may,
Mr. Hall, some of those people you denied.
what, Commissioner, Mr.
This was
Hall,
done by the administrative staff, though. This
Right.
particular one we'll be looking at.
I understand that.
Commissioner Walton, you're recognized, sir.
All right, I'd like to kind of get us back on track talking about this Policy 11 recommendation, where essentially you're going to have the director or, have an experience interview set up with a commissioner. We'll still have that portion in place. And I think the vote here is if that commissioner that interviews the trainee recommends for licensure, that the board, that the administrative office could go ahead and issue a license. I've got to say my position on that particular policy is that I think in 99% of the time it's fine. But we don't know what challenges could be faced in the future by this board. There could be extenuating circumstances. And I feel like we're kind of throwing out a policy that's been in place for years and years for the sake of convenience. And I do think that, in my opinion, I'd not be in favor of that.
Okay, Commissioner Thomas, you're recognized.
I just have a quick question for Keely. If you send someone to me in East Tennessee and I'm interviewing or reviewing their their experience credits, am I not acting on behalf of the commission? And is that violating the Sunshine Law?
I mean, the law says that they just have to make their information appraisal reports files available to the commission. Whether that means the entire commission, whether you would be acting as the commission, I mean, that's a good question. I guess if you are the reviewing member and you're meeting with that person, then
The Sunshine Law
In
would
a
be
s-
two or more of the board members.
in a sense you would be acting for the commission. But I don't know that it violates the Sunshine Law because you wouldn't be discussing business with another board member outside of this meeting.
But I think in a technicality, the way it's set up now, when you're conducting an experience interview, you're really not doing commission business. You're performing kind of an administrative function in conducting the interview. But I do think that you could be crossing over if you had the sole power to approve that license. Then you might be crossing into conducting commission business. Whereas another reason I think it's better to keep it black and white, have the commission conduct commission business and approve those licenses as a board. Have more eyes on it. I don't think that's a big problem versus the potential for that this policy could lead to in the future.
And I want to follow up with this. I know on the certified generals, sometimes we used to have two commissioners sitting in there during the experience interviews rather than just one. Sometimes it's just one, but sometimes as I look at them, I want to have somebody else there as backup, just so that there's not on those, because sometimes those certified general reports are not up to snuff.
And I never intended for it to be at your offices anyway. So,
Right?
if it's causing this much discomfort, I withdraw the policy recommendation.
Well, I guess my question is, we can either table it or we can vote it up or down now. And
Let's make a motion.
Motion to table, Commissioner Hall, is there a second?
I'll second.
Commissioner O'Hara, all in favor signify by saying aye.
Aye.
Aye. Roll call, please, on the table. Commissioner Johnson, let me clarify
Okay.
what we're voting on. We're not voting on this policy, whether if we like it or don't, up or down. What we're voting on is to put it on the table, lay it aside, not deal with it today, can bring it back up at a later date, or it can die on the table. But we're not gonna and as moving forward, it'll always be like it has been until this is resurrected. So that's what you're voting on this table.
So yes would mean table it, no would be vote on it.
That's right.
Okay, no.
Commissioner Thomas?
Yes.
Commissioner McCara?
No.
Commissioner Collinsworth?
No.
Commissioner Walton?
No.
Yes.
Commissioner Hall? Yes.
No.
No. Commissioner Johnstone votes no, yes, excuse me. So we have 5 noes and 3 yeses, so the table fails. So,
I'd like to make a motion that we vote down this policy.
that's a negative motion, voting down. So the recommendation, let me point of clarification. The recommendation is that we approve it, so if you vote
All right.
no, then you're voting, I don't want this. If you vote yes, I do want this.
I make the motion that we disapprove this policy.
Well, then that's a negative motion. I guess here's the way to technically do
Move
it.
to approve it. Then
Is just
if you
make,
wanna vote
whoever
against
wants
it,
to
you
do
can.
this, make a motion to approve in a second, and then you can vote no if you don't like it, and, yes if you do like it.
I'll make a motion, we approve this recommendation.
Second.
Okay, we have a motion to approve, Commissioner Collinsworth, seconded by, Commissioner McCara. Now, is there any more discussion? If not, we're going to vote. And what your vote, if you vote yes, that means that that's what this policy 11 recommendation is, what you want to do moving forward. If you do not like policy 11 recommendation, you vote no. And we're going to start to my left with Commissioner Point.
No.
Is that,
No is disapproval, yes.
okay.
Commissioner Hall?
Disapprove.
No, okay. Johnstone, no. Walton?
No.
Collinsworth?
Yes.
McCara?
Yes.
Thomas?
No.
Ms. Johnson?
No.
All right, the noes have it. Policy 11 recommendation fails. Okay, still under Director's Report.
We have an applicant, Thomas W. McCambridge from Franklin, Tennessee, who agreed to the voluntary surrender of his certificate to practice as a residential appraiser in Pennsylvania, along with any other licenses, registrations, certificates, or permits issued by the board for a minimum period of 5 years because he failed to complete an appraisal assignment within the requirements of USPAP, failed or refused to exercise reasonable diligence in developing an appraisal, preparing an appraisal report, or communicating an appraisal, and negligently or incompetently developing an appraisal, prepared an appraisal report, or communicated an appraisal. That was from the February 14th, 2013 Pennsylvania Action Report. This applicant has surrendered his appraisal credential in Pennsylvania and has applied to become a registered trainee in Tennessee. His documents relating to the disciplinary action are included in the board documents. This is the 3rd trainee for the supervisor requesting approval. The executive director, based on reviewing the disciplinary action report of the Pennsylvania, recommends this applicant be denied as the state from which he originally credentialed prohibited his reapplying for a minimum of 5 years. And it has only been 2. And he is applying in another state. This seems inconsistent with their implied intention as to protect the public.
Thank you. Ms. Favors, you've heard the applicant's character question and disciplinary action report and a recommendation from the director. Is there any discussion from this body?
I just want to ask a question.
Mr.
Is there a
Thomas?
significance to the statement, this is the 3rd trainee for the supervisor requesting approval? Does that mean the other 2 have been denied?
No.
Okay.
supervisors are only allowed maximum of three
Fine.
trainees.
I just couldn't figure out why that was in there.
Also, Mr. McCambridge is here today.
Sure.
So if you have any questions for him about the discipline, I'm sure he'd be glad to come up to the microphone and speak.
Anybody want to hear from Mr. McCambridge?
Yes.
Okay, Mr. McCambridge, if you don't mind coming up and addressing this commission, we would be appreciative.
Thank you for the opportunity.
You have the floor, sir.
What Miss Ayers said was correct, but with regards to the surrender, my wife and I had made the determination to move to prior to those actions occurring. I received the notice that there was that they had found my appraisal at fault, and what they wanted me to do with the consent was after we were already living here. And I discussed matters with the state of Pennsylvania, with my personal attorney, and since I don't ever plan to move back to Pennsylvania, and that wasn't ever the intention, it just seemed, rather than take on the monetary, going back, taking courses back there that would be necessary, I just decided not to do that. And that is why I surrendered my license. I never had an intention of being in Pennsylvania ever again.
I ask what the violations were that led to this action?
It was comparables. There was a disagreement with the comparables I used I actually did 2 appraisals of the property in question. One was prior to any improvements being made to it, and the second was with the improvements to the property. And the review appraiser, and this occurred after, well, to just add a little of the history of this case that I learned after the fact, I did the appraisal in 2008, when, on the East Coast in that area, values were still pretty strong. We, hadn't really seen the beginning of the drop-off. The owner of the property died, and I guess during the process of trying to sell that property, the original appraisal was reviewed, and the review appraiser just found that some of the comparables I used, he felt that did not meet what my peers would have probably used, and that's where those 3 violations came from. So it wasn't anything that was done intentionally or maliciously or fraudulently. There was just a disagreement about the comparables that I used in my appraisal. He felt there were other comparables that were better that would not have resulted in the same valuation that I came up with. That's outlined in all the information I provided Ms. Ayers.
You'd indicated you prepared this appraisal in 2008.
2007 was the first one.
So you had prepared one in 2007.
Correct.
Were both of these proposed, or was it completed in 2008?
Now, what happened was I did the initial appraisal, and I guess what the lender and the borrower were hoping to obtain was a cash-out situation that would allow him to do the improvements he wanted to do. And the value, as I recall, didn't stand up to what they were looking for. And then I did an appraisal about 9 months later that was with the improvements in it, the additional square footage, the additional garage.
So in 07, it was an as-is value of a property. In 08, it was as renovated or repaired or refurbished?
Trying to remember exactly the initial appraisal, because that wasn't the one it was actually the second appraisal was the one that and I guess I should keep my comments on that more, because the first one really, that was not ever an issue or wasn't brought up with the.
When was this turned into the Pennsylvania board? How many years after?
2011, that I got any notice at all that there was any problem.
And who was the, who had turned that in? Was it the review appraiser?
Pennsylvania does not tell you.
Okay, so
You
was
do
the
not get
property
any
owner?
information. I have no idea who filed the complaint.
And it was 3 years later then?
Yeah.
Okay. Any other questions from this board? Thomas?
Is, Chris Fuller's gonna be your sponsor?
That is correct.
Is he here?
He is not. He's not able to be here.
What does he think about all this? I mean, obviously he's aware of it.
Oh, yeah, yeah.
Okay.
I've been, and I should mention, I've been working with Chris for the last about 2.5 years as his assistant. I do typing, help him with the formulation. We go out on inspections together. I work with him on measuring houses, taking what I've done for 22 years. So I work with him directly as his assistant right now. And our hope is that, you know, I can get back into the business here. In 22 years, this is the only thing that ever occurred. And had I stayed in you know, if I still lived in Delaware, we were never going to move here. I would have fought things back there, obviously. I wasn't. But, you know, we'd already moved to Tennessee. It just didn't seem at the time that it's what I needed to do, to go back there and take care of this for a state that I never planned to live in again. Hopeful that I can, you know, get back into the business with Chris in a manner that won't restrict me quite as much as what I do now, because I don't do anything as an appraiser.
You were certified residential?
Certified residential in both the state of Delaware and the state of Pennsylvania, with no other blemishes on my record, except this one thing that happened after we moved.
And you're applying here for a trainee?
That's correct. I've taken the courses necessary. You know, I went back through the appraisal, hopes that everything would work out, and took USPAP again. Took the basics and the procedure.
What happened to the Delaware license?
It expired.
Okay.
And when we moved, I didn't know at that time that I was going to stay in the profession.
Favors, is all of this consistent with the documentation that was submitted to the commission's office?
His credential was surrendered as part of a consent order.
In Delaware as well, or just?
Pennsylvania.
Yeah, right. And it expired in Delaware.
It expired in Delaware.
Commissioner McCara?
Well, as someone from New Jersey, I can appreciate your desire to live in Tennessee because I really love this state, and I'm not
Love it
sure
too.
what part of Pennsylvania you're from. But
Well, I was actually Wilmington, Delaware.
Okay.
I'm an ex-Delawarean.
all right.
Wilmington,
Well, that's
Delaware, but-
then we sort of trod some of the same turf. What you said when you moved here, it was not your intention to stay within the real estate appraisal business. Is that right? What changed your mind on that?
Well, Chris was someone that I had met through his someone he's having a relationship who was my brother's realtor when he moved here the year before. And my wife and I made the determination to move after what I felt were, and probably a lot of appraisals agree, was a difficult time in the profession. You know, 2010, 9, 10, 11 were not a fun time. My wife and I decided to make a life change in coming here, and I had planned to leave the real estate appraisal profession behind. Chris, as I mentioned, was someone that I knew right when we moved here because we had socialized with him, and he asked me to give it a chance and said, "Why don't you work with me a little bit?" I looked into other opportunities during that period, and like anything, you know, I've been in real estate since 1985, and it just, one thing led to another, and what started as just working with Chris part-time has over the years turned into a more job for me. And, I'm getting up there. I don't plan to work forever, but I do feel that this is something that I do very well. And I don't think that I'm a risk to the public, especially in the manner that I would be working with Chris if the. And it is fun again, I'll admit. Nashville, Tennessee, and this Middle Tennessee is a happening place to be in the real estate profession. And not to say that, that changes, the seriousness of the business we're in, but, it's an upward market in a lot of the places. Stable at best most everywhere we do business, and we're working with Chris. I'd like to keep working with him, and if I'm able to work back into the, actually being an appraiser as a trainee and then moving forward from there, what I hope will happen.
Other questions, Commissioner Collinsworth?
I'd just like to make a point. It's nice to finally meet you, Mr. McCambridge. You and I have talked on the phone several times in the past. I have reviewed a lot of work from Mr. Fuller for several different banks in this area, and I've seen your name in several of the reports. We've talked on the phone a couple of times, although I've never been able to actually meet you, so I'm glad to finally meet you. But I'd like to say, as a result of that, I do feel like I need to abstain from any vote on this. But I have seen your name quite a few times, and I have reviewed a lot of Mr. Fuller's work, and appreciate that.
Are we under any obligation to abide by Pennsylvania law?
No, you don't have to grant a credential to him because of the disciplinary history. But you don't have to deny it either. There are some issues with the public trust, so I did bring down the manuals for background. The board shall not issue a credential if the background of the applicant. So you might want to look at that before you vote. I did bring those.
This is not a reciprocity.
It's not reciprocity.
Right,
No, it's
reciprocity
defined to be
doesn't apply
trainee,
here,
but-
so that's not an issue.
Ms. Gambra, I have a question as relates to something that Commissioner Collinsworth had brought up. He had indicated that he's reviewed reports in which Mr. McCambridge's name is in those reports, and he's not a trainee within the state of Tennessee at this time. What exactly was he doing in those reports to be getting mentioned? I mean, to me, that's providing significant professional assistance.
Absolutely.
And if you're not a trainee, can you be doing that? And
Yes. USPAP indicates that anyone who assisted provided
I understand, but
significant
drawing
assistance.
maps and, and pulling, if I hire an engineer to provide me with a site plan or something of that nature, they are providing me with significant, things that I'm relying upon. But if I'm actually doing analysis and pulling comparable data, and I'm doing some of those tasks, I don't know what those tasks are outlined in that scope. That's somewhat alarming that you can, it's kind of it's averting the rules, I guess, so to speak. Yes, please.
The comment that is in the appraisals that I've worked on with Chris just states that I am his assistant, helped in the production of the report. What I do is not the valuation end. I mean, Chris and I talk, obviously.
Well, that's what I was trying to clarify, because
But I don't pick
when
the
Mr.
comps.
Collinsworth made that statement, I know he reviews, and I'm sitting there thinking, that was not clarified there, so.
And I think the reason we have spoken, I'm easier to get a hold of sometime in the office than Chris is. I had a chance to answer some questions, but, I don't think they were ever of a matter that was a valuation type thing.
All you recognize?
Are you made application here to the state
Beg your pardon?
You have to be a trainee before you could make application if you wanted to move up from.
It really has to do with experience, I think, more than, have to, it's 2 years or X amount of hours, I believe.
2 years and you've got to.
Consequently, if the commission were to say, okay, you may become a trainee, that would take 2,000 hours before you could make application to become a certified residential or licensed appraiser or anything, correct? At that point in time.
I'm not looking to jump back in as a certified. I'm willing to, start as a trainee again. Quite frankly, I don't, I'll be perfectly honest. I'm not a young guy. I'm going to be 60 this year. I don't know that I'm going to be working in this profession for 10 more years.
I'm going to ask you a question. You might tell me. What could you have done that they would have said, this is so bad, this is horrible, that we're going to take your license from you?
They weren't going to take my license. I just
Well-
didn't agree to the terms and the fines and the education that they wanted me to take for a license that I never planned to renew. I was not found guilty, or I wasn't going to get my license suspended or revoked. This was strictly the consent agreement was for me to take a USPAP course, I believe, sales comparison course, and pay a fine. That is what the consent agreement was. And I chose, rather than to accept the consent agreement, I consented to the other choice, which was to surrender my certification that was going to be invalid within months anyway because it expired. Does that make sense?
At which time they said that you did not pay a fine and you did not agree to take the additional courses that they had recommended at that point in time, correct?
That's correct. I believe the consent agreement that I provided to the council stated very clearly what I could have done and what I chose not to do. But this was not about getting my license or my certification suspended or revoked.
You've lived here in Tennessee. Did I hear you say that you've taken the USPAP course?
Yes, sir. Through the Appraisal Institute, I've taken the USPAP course, the Appraisal Principles course, and the Appraisal Procedures course, all in the last quarter of 2014 through the Bluegrass chapter in Louisville, up the road.
Commissioner Walton, you're recognized, sir.
I've got to say, I think you seem like a knowledgeable, good guy, but I think the issue here is a matter of principle. And I don't think that as principle, I can side on the side of going against it. Your license is revoked for 5 years in Pennsylvania. We haven't hit that point yet. I feel like we're kind of undermining the other states' ruling and authority in their judgment in trying to protect the public by shortcutting this. And this is just my opinion. But I think I think you probably made a very bad judgment when you surrendered your license in Pennsylvania. And I think the beginning point for you, in my opinion, would be to go back and appeal to Pennsylvania and get that corrected before you came to us.
I don't think I have that opportunity. It was the document states that, it's a final decision. So and, I didn't realize I'd be here when I made those choices. Life goes on. Living with what I did, and I understand.
Oh, and that is, you've got another 2.5 or 3 years to live with what you've did, the choice you made. That was the choice you made, was to surrender your license for 5 years.
For Pennsylvania. It didn't say anything about any other jurisdictions. And quite frankly, I didn't give it a thought that I would be sitting here before the council, you know, that it would be a 5-year thing someplace.
Yeah, here we are.
Any other board members' thoughts before we vote on this recommendation? Do not have a motion on the floor. It would take an action from a sitting member here to take this recommendation from the staff and make it a motion, which basically denies the request. So as if you would vote yes if you believe that we should continue for the balance of the 5 years, or if you want to allow Mr. McCambridge to become a trainee, then you would vote no.
I move that we accept the recommendation from the.
I have a motion to accept the recommendation from Commissioner McCary. Is there a second? The recommendation is that we deny the trainee licensing.
I'll second that.
Okay. So we have a motion on the floor from Commissioner McCary, seconded by Commissioner Walton, that applicant will be denied from the state the licensing credentials at this time. We will start with Commissioner Point and move this direction to her right with a roll call vote. A no means that you want to, that you disagree with denying it and you want to let him become a trainee. A yes means that you want to be consistent with Pennsylvania's policy. Commissioner Point?
Yes.
Commissioner Hall?
No.
Commissioner Johnstone, yes.
Commissioner Walton, yes.
Commissioner Collinsworth abstain.
Commissioner McCary, yes.
Mr. Thomas, no.
Commissioner Johnson, yes.
5 yeses, 2 noes, 1 abstain. Does anybody wish to change their vote? Not, the recommendation stands. Approved.
So,
At this time, the board has decided to not allow you to be able to become a trainee within the state until this time expires.
so basically, I can come back to you when the 5-year period is up. My training.
My understanding, you wouldn't even have to come back to this board at that time. You could just apply directly.
Another check. I'll still have to check the box that it happened, though, you know?
Yeah, we'll still have your documents on file.
Okay. Well, I thank you.
Cambridge, have you met Chris Fuller's uncle yet, Wendell Alexander? Him and Chris's father or brother, Fuller, was all from out there. Yeah. Good luck to you in the future.
I guess, are we ready for the legislative update at this time, Commissioner Avers?
That was already part of the director's report, so that concludes everything from the
Would y'all want
director's
to take a
report.
5-minute break before we come back with legal? Or
I
you wanna-
I
before we
need a
go?
5-minute break.
Okay. We stand adjourned for 5 minutes.
Yeah, I was going to ask for it.
Tennessee Real Estate Appraisal Commission will come back into session at about 10:35 a.m., and we are ready for the legal report. Ms. Gamber, you are recognized.
Okay, thank you. Are you guys ready? You have it in front of you and everything? Okay. Item number 1, 2015-001551. This complaint was filed by the FDIC Division of Risk Management Supervision and alleged that respondent failed to comply with USPAP standards. The complaint alleged the appraisal was deficient in the following areas: scope of work and standard 1 real property appraisal development. Specifically, the complaint alleged that the support for assumptions is lacking. The appraisal relied on a discounted cash flow analysis to arrive at an as-stabilized value. However, the appraisal lacked a feasibility or market analysis to support projections and assumptions. In addition, numerous exceptions are detailed that highlight deviation from standard 1. The appraisal did not include support to project revenues and expenses, and the commentary did not support capitalization rate assumptions. The final reconciliation information fails to provide sufficient support between the two approaches used or reconcile value differences. Respondents sent a very lengthy response to the complaint, contending that the scope of work is consistent with the appraisal of real estate similar to the subject, and that the scope of work is consistent with that of peers performing similar appraisals for similar type properties within the geographical area. Further, respondent states that the appraisals developed with data submitted by the client illustrating revenues and expenses which are reconstructed to conform to acceptable appraisal practice. So the reviewer's conclusions are listed there, and right after that we have the response by the respondent to those conclusions. In this legal report, all of these seem to be extremely lengthy, so I will give you a second to just look over those, maybe more than a second. And then just let me know when you're ready for the recommendation.
Thank you, Ms. Gamber. And for the commission, we do have a lengthy legal report today, so let's try to expedite these as fast as we can. Thank you. I had opportunity to read through this. Ready? Okay. Amber, you're recognized.
Council recommends the authorization of a civil penalty in the amount of $1,000 to be satisfied within 30 days of execution of the consent order, such terms to be settled by consent order or formal hearing.
Heard the council's recommendation. Any thoughts from this body? Commissioner Collinsworth? You looked like you were ready to speak.
He just really
I
wants
was
you to say
waiting
something.
around to see if anybody else did on this one.
Let's
I'll tell you what,
let's just hear some thoughts before we make a recommendation. Commissioner Walton, you're recognized.
well, I mean, it's obviously was a pretty complex assignment. I think reading some of the commentary, there's some things that just the rebuttal from the respondent that didn't really hold water with me, and I'm not 100% sure that he gets it, what he did wrong in the appraisal on some of these. But at the same time, too, he's a certified general. He's been licensed since '91 with no. Well, let's see. No, he does have one or two disciplinary actions with letters of warning. So I do think it's time to step it up some. I'm not sure I want to go $1,000.
Well, thank you. And, as I read through it, it is a complex assignment. And so a question I have for council is, was the reviewer that reviewed this, was their experience or were they geographically and competent as well to handle this review?
You're asking if the reviewer was
Yeah,
incompetent?
was it, well, no, I don't know if he's incompetent or not.
I thought that's what you said,
I'm asking,
geographically
was he
incompetent.
geographically competent with this, wherever this occurred? And are they a competent appraiser? Because this was a complex assignment that I would say that not every certified general appraiser would be able to perform. So,
Yes, sir.
okay.
We engaged them specifically for this.
Recognize.
I want to ask a question to council. Is there some specific schedule of fines that you have, or do you what's the basis for determining that this ought to be $1,000 as opposed to $500 or $1,500 or whatever it might be?
Right. There's not like there is a schedule of things to consider when you were making recommendations. In this case, we felt like there were several negligent things as well, rather than just, I guess, competency issues. And there have been 2 letters of warning in the past, and I mean, there is a schedule. It's not, I guess, super cut and dry. It's just things to consider. Okay. So that's why we went with 1,000 in this case.
There's no need for experience. I mean, not experience, no need for education. Because apparently they're keeping their education up. It's more of
Correct.
a.
We didn't know that it would be a huge benefit in this
Right.
situation.
Honestly, to me, some of the stuff just looks a little bit lazy, where he thought that going 60-mile radius for looking for trailer park sales was adequate. I think if you've got a property of that magnitude, you might even cross state lines looking for comparable sales and data, and 60 miles doesn't seem adequate to me. He complained that the client didn't provide him with a plat of the property. Well, we all do our own research. I mean, we're responsible to do that. So it just seems, let's say, I'm not 100% sure that he gets it if he's using that as a rebuttal. So,
Commissioner Point?
I don't think the civil penalty is enough.
Okay. So we've got 1, that the civil penalty is not enough, 2, that the civil penalty is too much, so maybe we're okay.
It's kind of like The Economist. It says,
Split the baby.
it says put your head in the oven and your feet in the freezer, and you're pretty much average.
I object to the joke about an economist, please.
Okay, let's try to move on. If
I move to accept the council's recommendation.
motion to accept council's recommendation, Dr. McCara, is there a second? Is there a second to accept council's recommendation?
Second it.
Seconded by Commissioner Thomas. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Okay, recommendation, motion approved. Ready for 2015-001921. Ms. Gamber.
Complaint was filed by a consumer and alleged that respondent undervalued a residential property. The complaint alleged that respondent did not give the project due diligence, which cost the complainant the appraisal fee, credit report fee, and many more dollars in continued primary mortgage interest. Respondent sent a response to the complaint stating she completed prior inspections of the property, which she disclosed up front to the lender. They were both at a considerable period in the past and were completed for a different borrower and different lender. Respondent stated that the current lender had no issue with this, and neither did respondent. Respondent admitted there were errors in her report, but they did not affect value. A month after submitting the report to the client, respondent stated she received a message from the lender that the borrower was asking for a reconsideration of value based on the information contained in the prior appraisal. Respondent then submitted an addendum to the reviewer, not assuming that this addendum would be supplied to the borrower. Respondent stated that she did not feel motivated by any of the subsequent data presented from the prior appraisal to change her indicated value. Respondent stated she never heard anything back from the lender and that her fee is not paid based on whether the appraised value meets anyone's expectations. The amount of the fee is set by the lender. Respondent stated she did her job and cannot help that the appraisal did not meet the borrower's expectations. The reviewer's conclusions are again listed there, along with the respondent's response to those conclusions. So just let me know when you're ready for discussion.
Thank you, Ms. Camber. If you would, please look over this and at this time. Everybody had an opportunity to read through this? What's your recommendation?
The recommendation is to dismiss the matter as the differences in opinions appear adequately addressed and the reviewer's conclusions very minor in this instance.
For council's recommendation,
Move to accept council's recommendation.
motion to accept from Commissioner Hall, seconded by
I'll second.
Commissioner Walton. Any discussion?
Collinsworth.
Commissioner Collinsworth. Commissioner Walton, did you want to discuss this? Okay. All right,
We do look alike.
A lot.
they'll both remove in your mouth. No, I'm kidding. Any other discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Council's recommendation approved. Number 3, 20150033571. Ms. Gamber.
Complaint was filed by a federal credit union and alleged that respondent overvalued a residential property by reporting incorrect lot size and sewer system. The property has no septic tank, nor did it ever have a septic tank, and the lot size is too small to support a septic tank. There's no city sewer available for this property. Further, the complainant has to sell the property for the land value only, which is $2,400 as per the tax value. Respondent filed a response to the complaint stating the owners of the home told him that they had a well and a septic system. Respondent stated court records show individual well and septic. Respondent stated it also showed the lot dimensions as 100 by 185. Respondent only informed the bank of the information that he received from the homeowners and the source that is typical and usual from the courthouse retrieval system at the time of the inspection. Respondent stated the public records available on the data proves that he did nothing wrong in those areas. The reviewer's conclusions and the respondent's response to those are listed there, and just let me know when you're ready.
Thank you. I had an opportunity to read this. Okay. Ms. Gamber.
Council recommends the authorization of a civil penalty in the amount of $500 to be satisfied within 30 days of execution of the consent order, such terms to be settled by consent order or formal hearing.
Heard council's recommendation. Any discussion?
Yeah, I wonder in a case like this, obviously the guy appraised the wrong piece of property. It's about as negligent as you can get. Would there be any recommendation for some classes for this guy?
How do you take class in appraising the right property? I didn't know
It
how
sounds
to.
like appraisal
I didn't know how
101
to
to me.
help with the
It
recommendation on that.
It also seemed like the
GPS
response on
101.
this one was a little. It also seemed like the response on this one was a little. I mean, this is what we got for the response, and it's kind
Well,
of.
and if you look at their licensing history, they've been licensed appraiser since '91, and they've had one complaint in '94 that was dismissed. So it sounds like they've been doing houses for a long time, which may lead to why they were haphazard in their response. Been there, done this for a long time.
Can we require an eye exam?
You can require anything you want.
Tell them that.
I make a motion to accept council's recommendation.
A motion to accept council's recommendation. Commissioner Hall, is there a second?
I'll second.
Commissioner Walton, is there any discussion? Not all in favor signify by saying aye.
Aye.
Any opposed? Council's recommendation is accepted. Ready for number 4, which is case 2015-004131 and 2015-004141. Ms. Gamber.
Complaint was filed by the staff of the Tennessee Real Estate Appraiser Commission as a result of a trainee experience interview. This matter concerns supervisor and trainee in 3 residential appraisal assignments where USPAP violations were indicated by the reviewing board member. No response was requested prior to the review being conducted. The response was requested after the review was completed. These reviewers' conclusions are extremely lengthy. There are 3 separate properties on this one, and then the respondent also understandably provided an extremely lengthy response to those conclusions on the 3 properties. So give you a second and you just let me know when you want to proceed.
Thank you. Yeah, has everyone had opportunity to review this? Amber?
The supervisor in this matter has been disciplined before for significant violations of USPAP. As such, council recommends the authorization of a civil penalty in the amount of $1,000 for the supervisor, and both the supervisor and trainee be required by consent order to attend a 7-hour supervisor trainee course and a 15-hour residential report writing course to be satisfied within 180 days of execution of the consent order. Such terms to be settled by consent order or formal hearing.
Council's recommendation, any discussion?
Yeah, I've got some concerns about disciplining a trainee for working under the supervisor. But at the same time, too, I see if they've been trained this way, they may need some retraining. So in that case, I see that education. So
I agree with Commissioner Walton on that. I don't know how long they've been a trainee and whether they were required to take the supervisor and trainee course, or did they come in before that? And if they haven't, I have had the course, and it's a very good course. And it would it would behoove either one of them to take that course.
It says there that they've been a registered trainee since 4/16 of 2012.
So they would not have been required to take the trainee course, which is going to tell the supervisor and the trainee things that they did not know they were supposed to do. It's going to be beneficial to them in the future. So I like that education requirement there. Good job. Any other discussion? Do we have a motion to accept or amend?
So moved
Is that accept or
to
amend?
accept.
Okay.
Yeah, I'll move we accept their suggestions.
Second.
Second.
We have a motion to accept from Commissioner Collinsworth, seconded by Commissioner Point. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Council's recommendation is approved. Item number 5, 2015004331.
Complaint was filed by an appraisal management company and alleged that respondent's report contained inaccurate and misleading subject improvements description, missing and unsupported adjustments, inappropriate comparable sales selection, and inadequate reconciliation of value. Respondent sent a response stating that the tax records indicate that there were 2 dwellings on the property. The borrower specifically expressed he did not want the manufactured home to be included in the appraisal because it was not his property. He did not want it included as collateral in the loan. Respondent stated he did the report, stating specifically that the manufactured home and improvements were the personal property of a family member and given no value in the report. This type of arrangement is typical and common in this general market area and is not considered detrimental to value. The perimeter block foundation of the manufactured home does not touch or support the dwelling in any way, though it appears to be permanently affixed. Respondent stated the complaint is correct in that he did not provide personal photographs of the comparable sales and listings in the report as required by the client's guidelines. Considering the distances, travel time, expense, and photo quality, it was not considered productive. The MLS provides quality photographs and even more interior photos give the appraiser a true exposure to overall maintenance condition, quality of workmanship, materials, and improvements. There are a couple of reviewers' conclusions listed there, along with the respondent's response to those conclusions. So it shouldn't take long to just glance at those, and then I'll let you know the recommendation.
Hey, has everybody had an opportunity to read this?
I make a
Ms.
motion,
Ki-
I make a motion that we accept the recommendation of council on this.
Okay, we have a motion to accept council's recommendation. Can council please read into the record the recommendation?
Yes. Respondent's been an appraiser for over 16 years with no prior disciplinary action. He sent written correspondence to this office requesting his real estate credential be terminated as of May 31st, 2015. His credential expired on that date in the normal course of business, and he did not renew. As such, council recommends the matter be closed with a letter of caution with regard to the 2 reviewers' conclusions listed above.
Second to Commissioner Hall's,
I'll second.
Commissioner Collinsworth. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Recommendation approved. We're ready for item 6, which is 20.
Pardon me, before we move on, I'd like to thank our legal counsel for that recommendation in light of the fact that it's a property, appeared to be rural property out in the middle of nowhere where you've got there's no way in the world you could ever make a report comply with nothing.
Thank you.
Ready for item 6, 2015004771.
Complaint was filed by the staff of the Tennessee Real Estate Appraiser Commission after receiving a letter from FHA informing of HUD's removal with education imposed against the respondent for violations of FHA guidelines and USPAP. This complaint involves two separate properties at two separate locations. Respondent sent a response to the complaint stating he had multiple conversations with FHA regarding these two reports over the course of 3 months. At the time of the conversations, respondent was informed of a couple of deficiencies found by HUD concerning these reports which were not related to value, manipulation of data, misrepresentation of data, nor USPAP violations. Respondent has prepared many HUD reports prior to this random selection, having never received negative or positive feedback within the 7 years prior of being a HUD appraiser. Respondent stated that HUD preferred to see an excess land comment present, which was not provided as the first property had 2.66 acres present, and even though the second property had 14.48 acres present, it was not readily subdividable due to small entrance to the subject property and undeveloped land present behind subject, which would take some doing to clear, make an easement, and further subdivide. Respondent did not feel, given the specifics of the properties in question, an excess land comment was necessary. HUD did feel they were necessary and essentially suspended respondent's HUD-approved status for 6 months, based primarily on this comment not being present in either report. Again, there are multiple properties that the reviewer reviewed in this instant, and then the respondent has responded to those comments. Again, it's pretty lengthy. So just let me know when you've had more than a second to look at this.
Everyone had an opportunity to review this. So, Ms. Gamber, you are recognized.
Okay. The reviewer found several deficiencies with respondent's report, including violation of the ethics rule and the competency rule. Respondent has had prior disciplinary action taken against him, which required a significant civil penalty and continuing education. As such, counsel recommends the authorization of a civil penalty in the amount of $2,500 to be satisfied within 30 days of execution of the consent order, and a 15-hour USPAP course and a 30-hour basic appraisal procedures course to be completed within 180 days of execution of the order, such terms to be settled by consent order or formal hearing.
Thank you for that recommendation, Ms. Gamber. Any discussion from this body? I don't know that that's unreasonable based on the disciplinary history that's occurred since just 2012 and 13. It's fairly lengthy.
Move to accept council's recommendation.
Motion to accept from Dr. McCara. Is there a second?
Second.
Seconded by Commissioner Johnson. Any discussion? Not all in favor signify by saying aye.
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 Any opposed? Recommendation approved. Number 7, item 2015004931.
Complaint was filed by an appraisal management company and alleged that the respondent was not geographically competent in the area of the subject, and he failed to gain the requisite knowledge to be able to complete the assignment within the scope of work cited in the original order. Respondent sent a response stating that the claims are false and contradicted by the evidence. The respondent attached an email exchange he had with an employee concerning the request that he perform 2 compliance reviews for $70. The email states he can do both of these and have done about 100 of these for others over the past few months. I am not geographically competent in this area, which isn't necessary if these are just technical reviews with no opinion of value. However, I do have access to info in these 2 counties. He indicated the client indicated that he was good to go as long as he had the same data sources as the original appraiser without specifying what those sources were. The respondent further stated for the purpose of a compliance review, there is no requirement to have access to identical sources as the original appraiser. USPAP FAQ 293 explains that if the appraiser is engaged to determine whether or not the appraisal report under review complies with certain guidelines or standards, geographic competence is not typically relevant. He further clarified that he could not confirm or deny that the original appraiser's UAD ratings were accurate based on this data, as he did not have access to the original appraiser's work file and did not know if he had data not referenced in his report which confirmed this assertion. It stated that perhaps he needed further USPAP education and that she didn't believe that if he had been clear with agent that this report would have been assigned to him. She said she would get back to me after she spoke with the original agent. The respondent denies having done any wrong in this matter. The reviewer found the respondent utilized the best information available when doing his report and did meet the requirements of USPAP. The reviewer also found that respondent did do his due diligence in notifying the AMC prior to accepting the assignment. Respondent was being honest and forthright and was not attempting to mislead or violate USPAP. Thus, counsel recommends this matter be closed with no further action.
Motion to accept, Commissioner Hall, is there a second?
Second.
Commissioner Walton, any discussion?
I got a question.
Yes, sir.
Have we filed a complaint against the AMC?
There we go.
Why would they send an incompetent person? Because they swear to you day in, day out. We don't do that. We don't send incompetent. We only send people 10 miles.
You can open a complaint against the AMC if you feel like that's necessary. At this point, you're more than welcome. We can do that.
Just asking, how come staff hasn't done that? They're the ones saying you're incompetent, but we're sending you out there.
Well, and this was,
At your will.
this was,
I'm talking to the staff just for right now. Go ahead, I'm sorry.
right.
The complaint came in, I did not know if it had any merit, and I have to pursue the information that I have. It could have had merit that this appraiser did the wrong thing. So until I know, I don't just automatically open two complaint files, one against each other. I don't make decisions as to whether or not the complaint should. I don't prejudge them. That's for this body.
Collinsworth, you're recognized.
Well, it appears as though this was for a review that was done, and the AMC was saying the respondent wasn't competent. So without us knowing the whole story behind it, and we may have to do what you're saying, Commissioner Thomas, find out. But I'm wondering if the AMC ordered the appraisals originally, then the respondent, who was the reviewer, is who the AMC is saying was not competent.
They could have been ordering technical reviews, which have no
Right.
value opinions.
Right.
in
And
which
then
case
they
it
were
would-
saying the respondent wasn't competent to do it, is what I'm reading that as. But, of course, we don't know all of the work involved. Although I'm behind you, if it comes down to it, it may be that if the AMC ordered the appraisals and then also ordered the reviews from this respondent, then my question is why would you have ordered them from somebody who wasn't going to be competent in the first place, even though geographical competence wasn't required in this? But we don't know the whole story. I mean, it appears to me after reading it, an AMC possibly had ordered the appraisals originally. Then somebody did a review on them. The AMC didn't like the review, so they filed the complaint against the reviewer saying this person doesn't have geographic competence, which is not required in this case anyways. But, so we don't know the whole story, but it may be worth looking further into from that sense.
But if the
Hold on, let's make sure everybody's, if you finished?
I'm finished.
Okay,
I'm done.
Commissioner Walton, you're recognized.
I mean, but if the appraiser didn't do anything wrong, which it, based on what we've got here, which is very sketchy, doesn't seem like he did, how can the AMC have done anything wrong, other than filing a charge on him now that wasn't warranted?
Commi- I think what Commissioner Thomas's
But as
point
far
is,
as, giving the assignment to him, if the appraiser didn't do anything wrong, if geographic competency wasn't required, they did nothing wrong by assigning it to him.
But then they turn around and turn him
They
in.
turn around and,
Right.
exactly, and they're filing a
Right.
complaint that he's geographically incompetent.
I agree with Mr. Thomas. Somebody might want to, we might
Well,
want to look at initiating a complaint
Mr.
against the AMC. Can I speak, and then I'll let you have it.
I'm sorry, go ahead.
That very well may be what we need to do, is to investigate that further, the AMC's role in this, as directed by Mr. Thomas. Nope, Commissioner Hall's next.
I feel that the appraisal management company got exactly what they paid for, $35 each for those appraisals.
Yes.
I would recommend you call for the question on this matter, and then if you want to open an investigation on the AMC, we can do that as a separate matter. But
Agreed,
I'd
I agree.
rather you handle those as two separate items rather than tangling the votes on
I
these
agree,
two.
that would be the best way to handle it. So the motion on the floor is to close with no further action. And I can't recall who made the motion and second at this time.
Mr. Hall made the motion, Mr. Walton made the second.
Okay, Hall motion, second Walton. Any other discussion on that component? Not all in favor signify by saying aye.
Aye.
Any opposed? Okay, recommendation approved. Now, before we move to the next item, if Commissioner Thomas or Commissioner Collingworth would like to look at opening an investigation into the AMC, this would be an appropriate time to talk about that.
Again, I'm just going to explain the process with AMCs and the way these reviews go. What I'm reading is the AMC probably ordered the appraisal. Then it's highly possible that another lender ordered a review. The AMC filed a complaint against the reviewer and said they were not geographically competent. That's what I'm saying. So it's highly possible somebody else, not the AMC, ordered the review. We don't know all the steps involved in this situation. I mean, if it's up to Mr. Thomas, if he wants to pursue that. I work a little more with AMCs than probably most of you guys, so I know what goes on in the background as to the process of what happens. And the AMC doesn't necessarily have to be the one to order the review. Their client may very well order their own review, and that may have been what happened. And the AMC quite possibly may have filed a case against the reviewer saying this reviewer is not geographically competent. However, in this situation, they didn't have to be geographically competent anyways, as we see today. But
I don't read it that way, because it says the AMC alleged that the respondent was not geographically competent, and in the first line of the reasoning, it says the reviewer found that the respondent. So if
Right.
what you're saying is true, then the reviewer and the respondent are the same person?
no,
I mean, I know they're not.
the
but
way I'm
that's-
reading is the respondent did a review on the appraisal, and then we the state, had a review done of the respondent's response, the review that they did. Is that correct?
That is
Yeah.
the way
There
I
was a
understood it,
review
yes.
of the review completed by the respondent, who the AMC was saying was not competent to be doing the review. Clear as mud, right?
Yeah, so it's really clear.
So that's what I'm saying. We don't know all the steps involved in this case. I'm just telling you that's how AMCs operate. And a lot of times they don't necessarily have to be the one to order the review. It could have been their client who ordered a totally separate review, and then possibly, there was something wrong with the appraisal report they found a problem of. So the AMC may be defending their appraisal that was originally engaged by saying this reviewer was not geographically competent. And so therefore they filed the case. Yeah, that's what I'm
You
saying.
want to take any type of action, Commissioner Thomas? Okay, thank you. Ready for item number 8, 2015004961.
This complaint was filed by a consumer and alleged that respondent overvalued his property that he purchased on September 11th, 2013. The complaint alleged the appraisal of $370,000 in July 2013 was used to support the purchase price of $342,705. The sale closed on September 11th, 2013. However, subsequent appraisals conducted in 2014 and February 2015 both indicated a value of only $340,000. As the market and comparable sales do not indicate a drop in property value over 8% in a year on a newly constructed property, the original appraisal is vastly in error and indicates either gross incompetence or collusion with the lender and builder to support an inflated sale price. Respondent sent a response stating that complainant's complaint appears to stem from 2 subsequent appraisals done in September 2014 and February 2015. Respondent contends that while complainant forms his complaint on subsequent appraisals, he has not provided these reports with his complaint, and the credibility of the reports are unknown. At the time of sale of the subject, homes with similar quality features, level of upgrades, and size were supporting values above the contract price. In the complaint, complainant's allegations of incompetence and collusion are baseless. The respondent stated that throughout the process she has maintained appraiser independence, and the report has been completed conforming to all requirements set out by the state, USPAP, and the Appraisal Institute. The reviewer conclusions and the respondent's response to those are laid out. It's a little bit shorter on this one, so just let me know when you're ready.
I had opportunity to read this. Ms. Gamber, you're recognized.
Respondent's been a certified residential appraiser for over 22 years with no prior disciplinary history. As such, council recommends the matter be closed with a letter of caution regarding future appraisals.
So move.
Mr. Hall moved to approve, seconded by?
I'll second.
Ms. Point, any discussion? Not all in favor signify by saying aye.
Aye.
Any opposed? Recommendation approved. Ready for item 92015005561. Ms. Gamber?
This complaint was filed by a certified real estate appraiser and alleged that respondent's report has many inconsistencies, and there's no reconciliation as to why the appraised value is $67,000 with list prices and sale prices ranging from $18,000 to $42,000. Respondent sent a response stating he did complete an appraisal on the subject property and that the intended use was subject to after repairs value. The appraisal was completed on a URAR form at the verbal request of the client. Comparable sales were selected based on market knowledge of other sales that were renovated like the subject was to be. The report was completed for the client only. No other authorized use was permitted unless written or verbal authorization was obtained for the appraisal report to be released. No such authorization was obtained. The appraiser that submitted the complaint completed an appraisal on February 19, 2015, which was done as is. That is an issue, since a subject to and as is appraisal would render 2 different values. No follow-up inspection was completed by respondent to verify if the repairs had ever been completed. Furthermore, respondent states he has not had the opportunity to review the appraisal that complainant completed on February 19th. Respondent contends the complaint states that the as-is value would be $20,500. Of course, the as-is value would be lower than the one respondent arrived at, since his was subject to. Supporting documentation will show that the price range in this area is from $5,000 to $74,900, and that is MLS information only. It does not include sales or comps from local public records system. Supporting documentation will also show a limited number of sales from which to render a reliable market trend conclusion. No time adjustment was applied due to a limited data pool. There's a comment on this in the original appraisal report. The reviewer's conclusions and the respondent's response to those are listed. The respondent's response on this one is extremely lengthy. So take a second and then let me know when you're ready. Or more than a second, I suppose.
I had a chance to review the information. Amber, you're recognized.
Respondent has been a certified residential appraiser for over 21 years with no prior disciplinary action. As such, council recommends the matter be closed with a letter of caution regarding future appraisals.
Council's recommendation. Any discussion?
Motion, we accept it.
Motion to accept, Commissioner Hall, is there a second? Commissioner Thomas, seconded. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Recommendation approved. Ready for item 10, 2015006901. Ms. Gamber.
Complaint was filed by a consumer and alleged that respondent undervalued a residential property by misreporting the square footage. The complaint alleged that 3 appraisals were prepared by respondent. The property has not changed since the house was constructed, yet the square footage changed at every estimate. Respondent sent a response to the complaint stating the information for the first appraisal is not available because it was completed by respondent's son in 2009 and is beyond the record-keeping provisions of USPAP. The second appraisal was a 2055 FNMA drive-by appraisal completed 5 years ago, and the square footage was based on a lender-required verifiable record, which reflected the 5,056 square feet referenced by complainant. Also, being in a different market area, there were reasonable sales available to support the value conclusion at that time. The third appraisal was a recent FNMA appraisal, which required an interior inspection and measurements. The results of respondents' measurements produced a significant difference from the tax records, which were clearly incorrect in their reporting. Also, being 5 years after the initial drive-by, available market data varied significantly. Respondent stated he used all available comparables of reasonably similar properties within the scope of known lender-specific guidelines in forming his opinion. In the reviewer's opinion, there are no material issues in the uniform residential appraisal under review. USPAP was reasonably followed in the preparation and reporting of the appraisal. The analyses are appropriate, and the opinions and conclusions are credible within the context of the requirements. With regard to the major issue raised in the complaint, which is the difference in the square foot living area of the subject dwelling, the reviewer is of the opinion that the gross square foot area was correctly reported in both appraisal reports, considering the data sources. Respondent has been a certified residential appraiser for over 23 years with no prior disciplinary action. As such, council recommends the matter be closed with no further action.
Council's recommendation, any discussion?
I move we accept the recommendation.
Motion to accept by Commissioner Collinsworth, seconded by Commissioner Hall. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Recommendation approved. Ready for item 11, 2015007971. Ms. Gamber.
Complaint was filed by a consumer and alleged that respondent provided an inaccurate report and reported black mold, which caused a delay with closing. In addition, the complainant alleged that he has to pay for air quality tests to prove the respondent's unqualified observation wrong. Respondent sent a response stating there were no obvious signs of updating in the kitchen. The borrower stated there were no improvements to the kitchen. There was no evidence of any energy-efficient improvements. The property included a dwelling with no attached garage. There were 2 buildings that were used for storage for socks. Is that socks?
No.
I'm so sorry.
I didn't write that.
I really hope it's socks. Anyway, there were 2. I don't think I would have just made that up. Okay. There were 2 buildings used for storage for something being sold by the owner, which could have been
Can you tell us what
socks.
that was?
Socks,
Okay.
yes. One of the buildings included a 12 by 40 space with a gravel floor per one of the workers. Respondent did not identify this as a garage and gave it no consideration as a garage because of its location. Respondent stated she identified a fungus and supplied 2 pictures in the report. Stop laughing. I can't concentrate when you're laughing. Okay.
Oh, in Memphis, then I found a house just like that.
Okay. Respondent stated she was not an expert in the area and did not know if this posed any risks or hazards to the property. Respondent recommended the client get a professional inspection. She did not make an observation beyond the fact that a fungus was there and verified it with pictures. Respondent stated that it should be noted that the borrower states that the lender is using this appraisal to make the loan. The closing has only been delayed. Respondent stated she strongly felt that the client should be made aware of the situation to determine if they wanted to take any action. A review of the appraisal did not reflect any apparent violations of USPAP. Respondent has been a certified residential appraiser for over 21 years with no prior disciplinary action. As such, council recommends the matter be closed with no further action.
Heard the council's recommendation. Any discussion?
No.
So move.
Okay, Commissioner Hall has moved to approve. Is there a second?
I second.
Commissioner Point, any discussion? Not all in favor signify by saying aye.
Aye.
Any opposed? Okay, recommendation approved. Ms. Gamber,
That's all I have. I'm
Thank-
sorry. I'm pretty sure it's socks, so.
thank you for that excellent legal report, Ms. Gamber. Okay, that concludes the items. So far, we're ready for new business, or if we want to take let me ask you guys this. Do y'all want to soldier on all day and get this out of the way, or do you want to take a 30-minute break for lunch?
Break for lunch, a proper lunch.
An hour break or a full hour, 30 minutes, 45?
How long is this
The,
portion of the,
Well, the next portion, we've got some guests that we'll be introducing.
oh, so that's starting this
Then
next?
we'll have,
we're gonna break for lunch.
Evaluation standard discussion and AMC discussion. And there was like 10 individuals, I think, that wanted to speak, and so I'll set up a time frame and allotted times for those
Right.
speakers after lunch.
I don't think we want anyone to be hungry
Or hangry.
hangry.
Angry.
I think that we should take a proper lunch.
Okay, we're gonna take it, okay, it's 11:30. All right, let's be back here at 12:30, and we know what that means. Everybody will drag in at 12:45. So we stand
Or
adjourned
you can
until
actually go out if
12:30.
you'd like. I think we've got time.
Dennis, are we ready? Yes, sir. Okay. Call this July meeting of the Tennessee Real Estate Appraiser Commission back to order, and it is now 12:40 p.m. We're under new business on the agenda, and we've got a couple of issues there. And first, I want to introduce several of our guests that we have here today. We have members of the Appraisal Foundation here with us, members of the Appraisal Institute here with us, members of Arrow here with us, members of the IRWA here with us, and members of the Tennessee Appraisers Coalition, here. And we have members of Tennessee Department of Transportation here. Did I miss anybody, any group? If I did, raise your hand. Yes, sir, and you are? Residing appraiser. Oh, gotcha, American Society of Appraisers. Thank you. I am going to take the AMC federal law issue up first, considering it should be much shorter in duration. And I know Mr. Wiley has another engagement at 2 a.m., p.m., excuse me. 2 a.m. too, probably. And so at this time, I'm going to turn it over to Nicole to give us an AMC federal law update and follow up from the Arrow meeting, and then she can use Danny as a sounding board on that as well.
Well,
Ms. Avers, you're recognized.
As you know, recently the federal rules for appraisal management companies were issued, and as of August 10th of this year, they will be promulgated. So I invited Mr. Wiley to be present at our meetings in case any of you had any questions about the AMC rules. You all, well, not all of you, but most of you were present for the Fed's presentation at the beginning of the Arrow meeting. There's some changes we're going to have to make both to our laws and our rules, and I asked Danny to take a look at those to give us his expert opinion on what might need to be revised.
Well, I appreciate you asking me down, Nicole. As I think most of you know, I'm the chief appraiser at Service Link, and we are the largest independent AMC. We're not lender owned. We process several thousand reports a day, and we have a fairly big compliance staff. I have about 8 folks over in compliance who report to me that we monitor all the state AMC laws and try to anticipate actions that we're going to have to take in response to any changes that the state makes. As Nicole said, the final rules have been introduced, and we have been going through them state by state, kind of anticipating what we think some states may do with regard to changes. We have not finalized our formal review, and we also have a policy of not offering legal advice to anybody outside our company. But I just, really at this point, I'm not prepared to give you what we believe, but we are examining it. We're very curious as do you have any first reactions as to things you think you might want to change. And then of particular interest to us is regard to your audit policy, and if you plan, because we're already experiencing audits from different state boards, and some of you heard me talk about that at the Arrow meeting. So we're very concerned about that and how it's going to affect not only us, but all the states and all the appraisers. As discussed at the Arrow meeting, we would strongly encourage you to work with other states to the degree possible. The more uniform the audit requirements can be, I think that would be better for everybody. I know it's hard sometimes in the confines of each board working independently to get that kind of uniformity. I can tell you the state audits we have at this point are very diverse, very different, and some of them are quite expensive for all parties. So that's one area where we're of particular concern. I will tell you kind of unofficially, we see a few tweaks that we're anticipating that you guys are going to make, but nothing that we consider earth-shattering at this point. And I would be very curious as if you share that point of view.
One of the things that is omitted, and just at, on the first go-around that Keeling and I looked over the statute, the TILA reference is not in our statute. We're going to have to look at that and see if we can get an amendment to our statute to include that. We'll have to propose that possibly through the governor's package.
Any questions from the board? For either Ms. Avers or Mr. Wiley? Mr. Hall,
That did
you're
not come
recognized.
from Mr. Wiley. That was
Huh?
an internal observation.
We do concur with that.
No, I just have a quick question for Danny. Fortunately, Dan and I known each other for a few years and have a lot of respect for Danny and his knowledge and the way he runs his company. However, I'm still completely lost as to what you were talking about. I mean, what is it you expect us, when I say us, I mean committee up here, the commission. What is that's being changed that you think that we should consider? Very frank with you, after I heard you speak, I still don't know what you're talking about.
Okay, well, I apologize for that. One of the big things in the new rules is that your state AMC law has to give you the authority to audit AMC performance. Right.
What has to give us permission?
Your AMC law, your state AMC law, by the federal laws, the minimums require that you have at least the authority to audit the performance of the AMC. Right?
We do now, right?
Yes.
Okay.
But then how you act on that is entirely up to each state. So, for example, one state sent us a 2-page questionnaire, yes/no questionnaire, and that's what they consider their audit. Right? Some states sent us a lot more than that, with wanting full logs of how the USPAP audits we had done, documentation on appraiser actions that we had taken. And so you go from an audit that we can respond to in about a half a day to an audit that takes us, several weeks and lots of money to respond to. And then, frankly, some of the states are finding that if they go to that extreme, then it costs them a lot of money because they get it in and they have to process it. Right? So that's one of our And right now, of course, we do track, every state's different. We have a spreadsheet that we track all the different requirements. But the audit requirement in particular is one that in some states is fairly onerous, to be honest.
That only apply to federally related appraisals or what?
No. Well, it depends on the specifics of the state law. In most states, it applies to any transaction that we engage.
C company or as an appraiser?
As an AMC.
So, but what I'm asking though, so consequently, as an individual appraiser, if I get a call from an attorney and he says, I want you to take a look at my house. I think my wife is getting ready to take me to the cleaners on this one. Can you do the appraisal for me? Do I have to, or would any appraiser have to comply with USPAP if it's just applying a value to this person that is not federally related, no federal compliance whatsoever in it?
Oh, we're talking about the AMC law now.
I know that, but I'm talking about the appraisal that is made. What I'm trying to find out is appraisal, and AMC doesn't require it, but it is saying is affecting that they will not look at any appraisal. AMC will not order an appraisal.
Yeah, just make sure you speak into so everyone can hear you.
The question is, do we only order appraisals for federally related transactions? The answer is no.
So with those appraisals that are not for federal related transactions, would they have a different set that have to apply or could apply to them?
Well, state laws might allow that in certain states, but that's not.
That discussion is going to be carried
Yeah.
further in the next
Yeah.
session. We're just talking about our ability and what we have to do from a state to regulate the AMCs. Thank you, though.
Just curious.
I understand.
Okay.
You might draw me back up here when you get to that topic, but not right now.
Any other questions for Ms. Avers in relations or in regards to the AMC federal laws? If not, thank you for your
Thank
time,
you.
Danny. Ms. Avers? Okay. We're ready for the next item of business, which would be evaluation standards other than USPAP for non-federally regulated transaction assignments. I was asked to put this on the agenda by Scott, Mr. Diazio. I may not pronounce this right. Diazio? DiBiasio, okay. And Mr. Cole. And we have put this on here, and the way this discussion is going to work, they have 15 minutes to make a presentation and talk about these standards. And then anyone that wants to speak, and I see I've got a list here of speakers that wants to speak in reference to that topic, will have 3 minutes each to speak to that topic. Later, if you want to speak in reference to that topic in concert with a friend, you can speak for 30 seconds and yield 3.30 seconds to your colleague. So you can, we're not going to go, I guess the long story short is we're not going to go on to 6 a.m. with it. We're going to present the facts and then speak for or against it. You have 3 minutes. And I understand that Ms. Pettit and Mr. Disney want to speak last. And so I will honor that. And so if you start running over, I'll kind of say, try to come to a conclusion. Because there may be many statements that are the same, many that are different, and we'll see. So at this point in time, I'm going to turn it over to Mr. Diazio.
Thank you very much, Mr. Chairman. Good afternoon, everyone. We appreciate the opportunity to be here before you today, and we appreciate your accepting our request to come and talk to you about a topic that's very important to the Appraisal Institute. With that, I am going to turn it over to the Appraisal Institute President, Lance Coyle. Following his remarks, I'd be more than happy to answer any questions.
I just need to get close to it like this?
Yes.
Okay.
If it's red, you're good. If it's
Okay.
red, you're good.
Thank you very much. Chairman Johnstone, Vice Chairman Walton, and members of the Tennessee Real Estate Appraisers Commission. My name is Lance Coyle, I'm the 2015 president of the Appraisal Institute. I'm joined here today by Mr. Leslie Sellers here on the far end from Clinton, Tennessee, who served as the 2010 president of the Appraisal Institute, and Mr. Scott DiBiasio, who is AI's manager of state and industry affairs. We really appreciate the opportunity to speak with you today and appreciate you accepting our request to have just an initial discussion about the possibility of updating and modernizing the current Tennessee appraiser regulatory system. As many of you know, the Appraisal Institute is an 83-year-old society of professional appraisers with some 22,000 members and is the largest publisher of real estate valuation textbooks in the world, along with being one of the largest educators of valuation professionals. In addition, we've been involved in setting standards for many, many decades. What I'd like to talk about today is the possibility of amending the Tennessee State Licensing and Certified Appraisers Law to allow state certified appraisers to perform real estate valuations for non-federally related transactions using nationally recognized and highly regarded standards of valuation practice as an alternative to the uniform standards of professional appraisal practice. As you all know, under existing Tennessee law, all real estate appraisals, whether they be for federally related transactions, or what we call an FRT, or for non-federally related transactions, must be performed by state licensed or state certified appraisers in accordance with USPAP. That is the current law here in Tennessee. However, what appraisers around the country, including here in Tennessee, have been telling us, as well as users of appraisal services outside of FRTs, is that requirements to comply with USPAP when providing any non-federally related transaction valuation service, regardless of the client and intended use, are making it difficult to be able to effectively meet market and consumer demands. We do understand and recognize that there is flexibility within the USPAP document to meet certain needs, but we believe that it's not the best document because it is essentially trying to fit a round peg into a square hole. Let's talk about some examples. International companies and investors often need appraisal work done in compliance with international appraisal standards or those of their home country. And it's important to note that there are many valuation standards that are well accepted around the world. Some of these include the Red Book, the European Valuation Standards, the Japanese Valuation Standards, IVS, the Appraisal Institute's standards, and many others. By the way, last fall, the European Banking Commission ruled that multiple standards for lending were acceptable, but that the European valuation standards and not the international valuation standards were preferable. These types of situations that occur with international companies are frequently related to valuation for financial reporting or another similar use. We are in a global real estate economy that utilizes a range of valuation standards that may be more appropriate to a certain valuation question. Since the enactment of Tennessee's licensing law, other valuation standards have been developed, updated, or enhanced that may be more appropriate or germane in certain transactions. And USPAP may impose a level of work or reporting that is simply unnecessary or not germane in some cases, depending upon the use and the client. Right here in Nashville, you have 258 internationally owned companies, many of whom own real property assets. An example of a scenario where USPAP would pose an impediment to a Tennessee appraiser is if Volkswagen needs a valuation on their Chattanooga, Tennessee plant to be done under the European valuation standards and not USPAP for financial reporting or other investor purposes in Germany. A Tennessee licensed appraiser must refuse this assignment. Can't take it because Tennessee law requires that all assignments be done under USPAP. So what would happen? Instead, Volkswagen would likely bring an appraiser over from Germany resulting in lost business for Tennessee appraisers, and perhaps not the best valuation for Volkswagen. With 258 foreign company locations in just the Nashville metro area, this situation could occur. We don't know how much business is being lost by appraisers here in Tennessee because of this situation. In addition, there is the domestic area as well. We have situations where domestic users of consulting-type valuation services often don't need the types of information in an appraisal report that's required by USPAP. As an example, when the Tennessee Department of Transportation is in the initial stages of planning for a highway project, they'll often need a rough estimate as to the value of the land that they're going to have to acquire through eminent domain. They want to know roughly how they're going to budget for the project. A licensed appraiser in Tennessee would not be able to provide this kind of high-level portfolio-type consultation service because USPAP doesn't allow an appraiser to offer this type of information without going through all of the steps contained in USPAP and providing all of the information and documentation that is required to be in a USPAP-compliant appraisal report or a USPAP-compliant appraisal work file. This unnecessarily complicates the appraisal process. It increases costs on users of appraisal services, and in some cases it negates them from obtaining the service altogether, not to mention the fact that Tennessee licensed appraisers lose business opportunities because they cannot do this kind of consulting kind of work. Over the years, appraisers have also identified many other problems with USPAP that impact their ability to perform appraisal services for non-federally related purposes in an effective and efficient manner that meets the needs of their clients. Recently, the Appraisal Standards Board has talked about tightly regulating draft reports, something the litigation community, for instance, is strongly opposed to. USPAP, which was originally based on the Appraisal Institute standards, was institutionalized in the FIREA law of 1989 in response to the savings and loan crisis of the late 1980s, and it was specifically designed and targeted for mortgage lending transactions. Development of USPAP has been funded and partially overseen by the Federal Appraisal Subcommittee, which is made up of representatives from the federal financial institutions regulatory agencies. The Appraisal Institute supported USPAP in the beginning as a single valuation standard for lending transactions, and we still support that concept today. Nothing you will hear from us today has anything to do with not supporting USPAP for lending transactions. However, because USPAP's main purpose is to assist in the lending regulatory environment, it has become, over time, a rules-based rather than a principles-based set of standards. This makes it difficult to use in litigation support cases, tax appeal, financial reporting, and consulting situations. Contrary to what some believe, USPAP is not a single standard used by all. Indeed, the GSEs, the Fannie Mae's, and the Freddie Macs of the world, the Yellow Book, state eminent domain laws, and others effectively impose an additional set of standards on practicing appraisers. USPAP is updated every 2 years, often to make only minor changes of additional rules put in place to solve some lending situation which has been brought to light by bank regulators. This makes it extremely difficult for appraisers to keep up when it changes every 2 years. And it makes it almost impossible for clients and users of appraisal services to keep up with the latest changes. In short, they're just confused. USPAP may not be the most appropriate standard for every single valuation assignment. We believe that it's fine for the lending environment, but not every valuation assignment. Other standards of valuation practice may be more appropriate while ensuring the highest level of professional ethics and competence. I want to stress to everyone that the concept of any legislation that would be introduced would have no effect on the lending regulatory environment of FRTs where USPAP applies. What we're talking about here is only for non-FRT work, which is growing with our complex economy and international connections. Tennessee already has made exceptions to this. Tennessee recognized that USPAP compliance may not be appropriate in all valuation scenarios. In 2010, the Tennessee Attorney General released Opinion 10-25, which I have here with me today, that allows a state-certified appraiser to complete an evaluation for an FRT without having to comply with USPAP. This was a recognition that not every valuation service offered by a state-certified appraiser must comply with USPAP. Tennessee also allows state-certified appraisers to serve as advocates and to receive contingent fees when providing, quote, specialized services. This is another departure from USPAP. So what we're proposing here is that Tennessee law be amended to allow but not require, and I want to stress that, a state-certified real estate appraiser to utilize a well-recognized set of standards of valuation practice other than USPAP when performing valuation services for any purpose other than federally related mortgage lending transactions. Alternate valuation standards, whatever they are, would need to comply with well-accepted and well-understood principles of impartiality, fairness, and competency. Under such a proposal, standards of valuation practice would need to be approved by the Tennessee Real Estate Appraisers Commission. You would need to approve those standards to allow them in the state prior to being utilized by state-certified appraisers doing non-FRT work here in Tennessee. Given the similarity of most standards, this should not be a burden. You probably already understand the alternate valuation standards that are out there now. And there's nothing that would prevent this commission from charging a reasonable fee to approve an alternate set of standards. If an appraiser wishes to utilize a standard of valuation practice other than USPAP, it must be agreed to by the client and disclosed within the body of the appraisal report. Importantly, any legislation would not change in any way any of the requirements that appraisals for federally related transactions be performed by state licensed or state certified appraisers in compliance with USPAP. This legislation will not change any of the requirements for appraisers to be state licensed or state certified when providing an opinion of the value of Tennessee real property. Appraisers would still be required to comply with all other provisions of law unrelated to valuation standards. In addition, the legislation would not alter the ability of an appraiser to continue utilizing USPAP to perform any appraisal service for a non-federally related appraisal assignment. It would simply be an option. That option to use USPAP would remain. And most importantly, appraisers would still be required to comply with the highest level of ethics and demonstrate appropriate competencies. Are we talking about a big bunch of appraisal work here? No, we're not. In our estimation, only a very small subset of non-federally related real estate appraisal activity will actually be performed according to standards of valuation practice other than USPAP. An even smaller percentage of these non-FRT, non-USPAP assignments will make their way to you guys in the form of complaints. So honestly, we don't really see any measurable administrative burden being placed upon this commission to have this type of system in place. Now let's look very briefly at the accountants in Tennessee. The Tennessee Accountancy Act allows the State Board of Accountancy to recognize accounting standards other than those promulgated by the AICPA. This allows certified public accountants to be able to provide a wide range of services such as audit, tax, advisory, financial statement preparation to meet their client needs in a cost-effective manner. Accountants are required to comply with the rules of professional conduct regarding independence, integrity, objectivity, and confidentiality, but they're free to offer their services according to the standards most appropriate for the type of work being performed. In fact, if you look at a document published by the Tennessee Society of CPAs entitled Standards for CPAs, State-Specific Ethics, this quote is found: "The rules that apply depend on the client entity. For example, if you are providing a test services to a private entity requiring independence, you are required to follow the rules of the AICPA, your state accountancy board, and your state society. If your client is a publicly traded entity, you're required to follow the rules of the AICPA, the SEC, the PCAOB, and your state board of accountancy and your state society. We believe that Tennessee appraisers should be afforded similar standards flexibility while still being required to uphold the highest ethics and competency requirements. We also note that just last Friday, in a meeting with the International Valuation Standards Council, that they have agreed to move in this same direction as well. This is also a states' rights issue. In fact, your law states that the Tennessee appraiser law can be no more stringent than what is required by federal law. Federal law mandates that states require USPAP compliance only for federally related transactions. So what does this mean? That means that Tennessee is already over and above the federal requirements by extending mandatory USPAP compliance to non-FRT appraisal assignments. As demonstrated by the accounting profession with the Tennessee Accountancy Act, there's no compelling reason for one set of standards to maintain a monopoly on valuation standards in the U.S. when there are other national and international valuation standards that would provide the same level of assurance of appraiser ethics and competency and may be more appropriate for certain non-FRT valuation questions, including for purposes such as estate planning, tax and advisory services, and valuation for financial reporting. You will no doubt hear various arguments against this proposal. We've heard a number of those arguments before in Texas and in California. A similar law has already passed and is in effect in Texas, and another similar law is working its way through the California legislature. We don't feel like any of these arguments that we've heard are any reason for the Tennessee legislature not to enact this proposal. All this does is it gives options to appraisers to pursue business opportunities that they might not be able to pursue today and to fulfill client needs that they might not be able to fulfill today. It gives additional flexibility. And finally, while any anticipated legislation does not specifically require appraisal institute standards, legislation that we're talking about could involve standards from a variety of standards-setting bodies. So we don't anticipate that it would specifically require Appraisal Institute standards. We did recently update our standards, and there has been some criticism of us for doing that. So I'd like to explain why we did it. There are 17 states around the country, Tennessee's not one of them, 17 states around the country which have no requirement to be licensed or certified for non-FRT valuation work, and thus no requirement to comply with USPAP. Now, there are gray areas in some of those 17. It's not exactly cut and dried or clear. But you do have a number of states where if you're doing non-FRT work, you don't have to be state licensed or certified, and you don't have to comply with USPAP. So in other words, if an appraiser in one of these states is only doing eminent domain work, let's say, for, say, property owners, they'd never have to be licensed or certified, and by extension, never have to comply with USPAP. That's a gap, and a lot of our members came to us and said, we've got to have some standards that we can point to as ethical and competent standards that we can use in these states. Would you help us fill that gap? And for that reason, we updated our standards so that our members and others in these situations would have a set of high-quality, principles-based ethics and standards to comply with. I also want everybody to know that we've never charged a fee for our standards, and we have no plans to charge anyone, member or non-member, for our standards going forward. Really appreciate the opportunity to be here with you this afternoon. Of course, we're happy to answer any questions that you have.
Thank you for that presentation, Mr. Coyle, Mr. Diazio. Close.
Smith will be
T.
fine.
Beiser.
Scott.
I'm going to call you Scott from now on. All right, members of the commission, at this time, I'm going to allow you to ask questions of the presenters if you have some. Anybody?
I think what I
Mr.
may do,
Collinsworth,
if we
you're
don't mind,
recognized.
is I wouldn't mind listening to everyone and then asking questions at that point. If that's, will you guys still be here for us to be able to do that?
Okay, that'll be fine. At this time, then, we'll listen to folks that want to speak in reference to this. And we can start with, I'll just start at the top of the list and start working my way down. I have Miss Maggie Hamilton and Dave Button. Thank you, guys. If y'all got about 6 minutes, it'll be 3 each, or however you want to divvy it up.
Okay.
Thank you very much, Mr. Chairman. I appreciate the opportunity to appear before you today. My name's Dave Button. I'm president of the Appraisal Foundation. I've been the senior staff member now for the past 25 years. I've seen a fair amount of change in the profession. What we have here, just one quick point, the Appraisal Foundation, for those of you who aren't aware, is not a membership-based organization. We have about 95 organizations that are affiliated with us, but we don't have any individual members. For the past 25 years, the 50 states and 5 territories that license and certify appraisers, to our knowledge, not one has ever found the need to adopt another set of standards. And that's because of the flexibility of USPAP. So in some ways here, we have a solution that's in search of a problem. This hasn't been a problem. Last year, as Mr. Kroll pointed out, the Appraisal Institute did pass some new standards that instead of being in supplemental to USPAP, were in lieu of USPAP. So that's the biggest change now, is that they have essentially a competing set of standards. But USPAP for 25 years now has been in the federal courts, the state courts, administrative rulings. It's a much better document now than it was in the early years. When it was first created, it was cobbled together from various trade associations, and now it's, for lack of a better word, battle-tested in the courts. It's much more enforceable. It's rare that we find provisions of the document that are not enforceable. It's also highly recognized globally. It's considered to be one of the, if not the best domestic set of valuation standards in the world. There are a couple of press releases in the handouts that were given to you where we're working with the IVSC to have a bridge document so that you're going to be able to have a USPAP compliant appraisal. At the same time, it'll be IVS compliant, which would be huge. There's also another press release in there from the Royal Institution of Chartered Surveyors in which they talk about how Cushman & Wakefield, C.B. Richard Ellis, and others are very supportive of this convergence, not going apart, not having more sets of standards, but try to have more convergence out there. We are all about public trust at the foundation. The Appraisal Institute is a trade association, and it works on behalf of its members, and they play a great role in that. But we, again, not having members, we are about public trust, transparency. All of our meetings are held in the open, exposure draft process, comment letters are posted on our website. The proposal that you just heard would, I think, create a significant administrative burden for all of you. Right now, any complaint that comes in, you handle every appraisal that's complained about the same way. You don't separate between federal-related transactions and non-federal-related transactions. That would be the first burden. And sometimes that's not a clear line. It can get a little bit blurry. Secondly, you're going to have issues with reciprocity, temporary practice, and experience. The experience logs from people who now would be suddenly following different sets of standards, only experience in conformance with USPAP would count. So someone's going to have to be looking at all this. You're also going to have to be monitoring the various sets of standards to make sure that they're current. And we just think it would be a significant burden. It's also a view shared by many others. That back in May, Arrow had a conference here, and many of you may have been in attendance, and we polled the 170-plus regulators from over 30 jurisdictions by a show of hands, how many think the idea of having additional sets of evaluation standards is a good idea? 170 people in the room, not one single hand went up. In addition, there is a letter in your hands out there from the Appraisal Subcommittee, the federal overseer. They have concerns that if your already limited resources are stretched to monitor other standards and other transactions, that it could have an impact on your ability to effectively carry out Title 11.
You're one of about 36 states, I believe, that are mandatory. I don't ever recall one going from mandatory backwards. There's been some that go where they have it sort of a hybrid and they become mandatory, but I've never heard of an organization or of a state going the other way. Also, it's interesting, we are unaware of any organization that represents users of appraisal services that thinks this is a good idea. Not one. There's a letter in your handout there from the National Association of Realtors that says one set of valuation standards is what we should have. ASA is opposed to it. NAI, the National Association of Independent Fee Appraisers, is opposed to it. The American Society of Farm Managers World Appraisers is opposed to it. Groups like Morgan Stanley, a lot of other big groups. If you have a footprint in more than one state, you don't want to have less uniformity. You want to have more uniformity. A lot of them like to see a national license. So if now Tennessee is different than Kentucky, which is different than the Carolinas, you're creating more of a regulatory burden than what you currently have. I want to recognize my colleague here, Maggie Hamilton. She is the vice chair of the Appraisal Standards Board. I am not an appraiser, and she has some observations about the Appraisal Institute standards.
I want to thank everybody for inviting us to come and speak. Nicole, thank you. I am Maggie Hamilton, and I am the vice chair of the Appraisal Standards Board. I kind of come with a unique perspective in the fact that I'm also a designated member of the Appraisal Institute and have been for over 28 years. I'm a practicing appraiser and have been for over 40 years, so I've seen the various standards. And I also served on my state regulatory board for appraisers for 8 years. So I kind of have sat in all the positions, and I additionally served on one of the AI standards committees in prior years. And so my observations have been basically come from the letter that we received and that you all got as part of the AI's standards evaluation practice for non-federally related appraisals that they're using for their legislative actions in various states. And I'm referencing that because I think you all have copies and were sent copies of that document. And I just wanted to clear up some standard issues that are mentioned throughout the letter and some of the inaccuracies that I'm sure that most of you on the commission are already aware of because you use USPAP daily also. And I will say, when I carried this book up here, the first thing I thought was it does look very imposing to all of us if you look at the USPAP book. But if you divide it into sections that we all do, you look at the real property section, and it contains, if you leave out our 5 general rules and our advisory opinions and the statements, it contains 17 pages. So it's not an all-encompassing document right within the actual real property rules. It's very effective in that it is principles-based rules. It's very difficult to look at a principle which is lofty but doesn't have any meat to it. And we all have our own principles. But if you're trying to enforce a principle and you don't have any understanding of the steps that you would take, how can anybody comply or judge if somebody completed a principle in a correct manner? So our rules have, because of this, have had to become a little bit more stringent. Okay, so that was one thing. So it's not realistic from a professional standpoint. USPAP is flexible. It does help us in performing all types of assignments. It sets a minimum threshold for what's needed to produce credible assignment results. And I don't know any practicing professional appraiser that would want to do less than the minimums. Is my time up? Okay.
30 seconds.
30 seconds? Okay. So what I would like to do in summary is when if you decide to look at other standards from other people, we as commission members and as professionals, we must remember that AI and other professional organizations are promoting the interest of their members, which could be contrary to that of the public interest, whereas the commission and USPAP and the foundation must act in the interest of public trust. So I'd like you to remember that. Thank you.
Thank you. Thank you, Ms. Hamilton and Mr. Button. Okay, I have Mr. Dennis Badger next.
Before y'all leave, excuse me, before y'all leave, please, it's like our chairman asked for questions from Mr. Coyle, and I think Mr. Collinsworth said to wait until everybody had spoken. Is this what you prefer to do?
Oh, I don't mind. I was
Okay.
just saying,
No,
I may have some questions,
no,
but
I
I
got-
think if I wait till then.
My mind is not that long,
Oh,
and
go.
sometimes I remember things when I first hear it, and I
Well-
do 10 minutes later. I don't know. I'm not that old. I'm not that young anymore, I'm sorry to say.
Go
But
ahead.
I don't want to interfere. I mean, if that's just the
My intent was to hear all the
that's
sides
fine.
and then have the questions at one time.
Okay,
because
that's fine,
I
whatever.
think that'll be more
That's
fluid.
fine. I have no problem. I just had
We'll,
some
we'll be here
questions.
till adjournment, so that's
No,
fine.
that's okay. Thank you, sir.
Thank you.
Thank you.
And, oh, by the way, I did know Ms. Hamilton's husband because we served together back in the American Institute of Real Estate Appraisers. So we did go back in years gone by. You're not as old as I am. You better looking too.
Mr. Badger,
Thank you, Mr. Chair. My name is Dennis Badger. I don't have prepared comments because, quite frankly, I wanted to hear what some of the opening remarks were, and this is something that certainly means a lot to me, as well as many of the other appraisers in the room, no doubt. Again, my name is Dennis Badger. I'm the Vice President of Collateral Risk Management for Farm Credit Mid-America. We serve 4 states from Indiana, Ohio, Kentucky, and Tennessee. I also have a small appraisal shop in central Kentucky, where I teach continuing education courses and offer investigative services for a variety of different state agencies. So to give you a little bit of background, Farm Credit Mid-America is part of the Farm Credit System under the regulatory guidance of FCA. We have over $20 billion in owned and managed assets across the 4 states. So I can give you a bit of perspective from a lender's side, one of the intended users. We have a significant number of loan transactions that fall below the de minimis, the threshold of $250,000. While it is not a requirement that we utilize licensed or certified appraisers in those instances, those, by and large, are licensed and certified appraisers to which we hold them accountable to USPAP, regardless of what any other state regulatory body would have. We feel that it is extremely important to have independent, impartial, objective value opinions, to have no question on somebody's ethical requirements, their standards, and USPAP, quite frankly, provides us with a very common ground, a widely understood concept and basis behind our value opinions. We do not find it difficult to comply to USPAP. I think it is a very simple document, to be honest with you. Many times I frankly wish it was had more requirements. My great fear is if we have additional requirements that are possible within the states. Again, we simply have 4, but imagine the difficulty of having 4 different now sets in addition to USPAP. It is not even, what I understand is being proposed is not defining one specific additional standard to USPAP, but potentially many. And I know that would certainly be within your control as it's been described thus far, but where will that end? What would happen if we now have 6 different organizations that submit additional standards? It is difficult from an enforcement mechanism. From my experience of teaching investigators, over 300 some odd from various states and agencies, and I find that it would be extremely difficult to have experts in other areas of standards outside of USPAP. It is already, quite frankly, difficult to understand all the different assignment conditions from Fannie, Freddie, FHA, VA, the right-of-way associations, Yellow Book, et cetera. And if we lay in yet one more set of standard, again, it's going to create a nightmare from investigative standpoints. So I believe it could cause a litigation nightmare for state agencies because of challenges from individuals stating that the board does not have a qualified person in that set of standards sitting present, or a minority of a board that would be a membership of that particular organization. So I guess I'll just simply summarize by saying I think it would be a poor decision to endorse something such as this, and certainly value your opinion, and you have an open forum such as this. So thank you very much.
Badger. All right, got Mr. Button, Mr. Randy Button. You're going to yield your time to who are you going to yield it to? Just wait and see? Okay. All right. Okay, Mr. Turner, do you have any comments you'd like to say from TDOT's perspective, or? I noticed Mr. Hogue from TDOT came in, and we're glad to have him here as well. If you're going to speak, though, you will need to come up to the mic. Okay, all right. All right, Mr. Hedden.
Thank you, Mr. Chairman. I'm Mark Hedden. I wear several hats, kind of like Mr. Badger here. I work with the United States Department of Agriculture here in Tennessee part-time. I'm also the Government Relations Coordinator for the Tennessee Appraiser Coalition. And then I also have my own small shop that I've done appraisal work out of the past 24 years. You know, I don't know what the right answer is here, but I will tell you what I see. In working with the USDA the past several years, last year we did $10 million in loans in the state of Tennessee. These are in all counties in the state of Tennessee, all 95 counties, and we do all types of lending, everything from residential to all your water and sewer, your broadband cable in most of the rural areas. So we just commercial, hotels, motels, apartments. I mean, we literally do it all. What I see is a major disgruntle among appraisers in the state of Tennessee on several things that are going on and what to do and how to do. And with USDA, one thing that we do for the most part on the residential appraisals, they have to comply to USPAP. But on some of our other things where we're doing some grants or we're doing city services such as water and city municipalities, or even, something, some type of community facility or a farmer's market that you may have in your area, sometimes we don't require any appraisal, or we just allow somebody locally or a local realtor to come in and give us what they think that value is. So I mean, we've got a little toss up there that I don't know how to handle that. On the Tennessee Appraiser Coalition side, I've been contacted the past several months over this by many people, and a lot of them basically are the opinion that if it's not going away from USPAP and USPAP is still going to be in place, then why not have another alternative? What does it hurt if we have another alternative if there's something we can do? And so that's kind of my, I don't know what the answer is, but I mean, it does appear that most of our members of the Tennessee Appraiser Coalition are in support of another alternative. And that's where I'm at on it, so.
Thank you for those comments, Mr. Hedden. I've got Mr. Sellers. I had you down to speak. Are you? Okay. All right. We have Mr. Disney and Ms. Pettit up. Okay. Okay, well, you have 3 minutes. You're welcome to.
One at a time.
Okay.
Good afternoon, and thank you, Chairman Johnston and members. I don't know whether or not you have seen a copy of the letter from our Association of Appraisal Regulatory Officials. If not, you probably aren't familiar with my name. I'm Ann Pettit. I happen to be the Superintendent of Real Estate and Professional Licensing for the state of Ohio, and unlike my predecessor, Nicole, who is currently the president of ARROW, and I am the president-elect, I have the and professional licensing, so I'm ready for all sorts of other. I have 4 boards and commissions right now, everything from video services to real estate brokers, appraisers, salespeople, and cemeteries, by the way. So we try to cover everything. I'm going to make this short because we're speaking here to you as a state who will be taking into consideration the alternatives that have been proposed here. My remarks certainly would be much different were I to be in front of a federal panel today. The letter that I referred to just a moment ago, hopefully if you've not already seen it, they do have it fantastic, so I'm not going to read it into the record. But from our organizational perspective, Larry and I both would like to make very, very clear that we as an organization depend upon both the Appraisal Foundation, first and foremost, for the substance, the foundation of the Title 11 of FIREA regulations that we are required to follow, even in the minimum circumstances, and the Appraisal Institute, which certainly offers a plethora of education and, again, educational support, professional support to all of our appraisers. Ohio is one of the 17 states to which Mr. Coyle referred, although we're one of those really odd states because we also have a state statute that requires that a certified or licensed appraiser be used in the situation of any type of mortgage transaction, not just a federally related transaction for residences, but commercial properties as well. And across the board, anything where a mortgage instrument may be involved. So from our perspective, and I'll say from my perspective, as the president-elect of our organization, our 55 jurisdictions strive very, very hard to stay up on all of the different requirements, the standards. We do not find most of the time USPAP to be of burden, but I would say that at least from my perspective, we have a very set limitation of resources. I don't know about the Tennessee Commission, but the Appraiser Board in Ohio and my entire division, which handles over 80,000 different licensees, certificate holders, and registrants, has a very limited amount of resources. We want to make sure that this organization's central theme is that we look upon both of these organizations who are speaking to you, both for and against alternative standards today, as great resources to all of us, all 55 jurisdictions, and that we remain committed as an organization, ARROW specifically, to the leadership, cooperation, communications, and education of all of our members, realizing that, as was stated earlier, the matter you're dealing with today is very much a states' rights issue. We are each put into our positions in different ways and manners, but the reality of what we deal with from an administrative and enforcement perspective is and would be very, very difficult should additional standards be introduced into this arena. Thank you.
Thank you, Ms. Pettit. Mr. Disney, you are recognized for 3 minutes.
Thank you very much, Mr. Chair, members of the commission and staff and guests. It is a unique experience for me appearing before another board to speak, as I am the director of the Kentucky Real Estate Appraisers Board. I'm not appearing here today in any capacity with that position at all. Instead, I'm representing Nicole's efforts and Ann. I'm the immediate past president of the Association of Appraiser Regulatory Officials. And I want to say, for the record, I'm also, and have been since 1985, a member of what is now the American It was the old American Institute of Real Estate Appraisers. I'm now a member of the Appraisal Institute with the SRA designation, non-practicing. So full disclosure, I make that known. And I've worked closely with the Appraisal Foundation and the boards for years. But what I bring you on behalf of the ARROW group, which is the acronym for the Association of Appraiser Regulatory Officials, and following up with what Ann said, we have a unique partnership in that we have federal oversight and a private nonprofit, and the states that administer the programs with oversight from the appraisal subcommittee. So the ARROW Executive Committee and Board of Directors had a majority vote recognizing USPAP as being the only appraisal standard that the boards would support, so long as Title 11 and FIREA is written as it is today. We see no problem with any group having additional standards, but requiring the states to have multi-layered recognition, and which is what in essence it will become, numbers of standards within state laws permitting those standards, can be a problem, and I tell you it can have unwanted consequences. Having more than one standard of practice, and I've heard it referred to recently as having many horribles, and I could see where that would be possible for us. Reciprocity and temporary practice, as was stated, that certainly could become an issue depending upon what the states enforce and how they do it. Experience reviews. You had discussion today, as the board I represent and others have discussions about the steps. If we have multiple standards, imagine trying to now go through and look at each report and a representation of those reports for that satisfactory compliance. Enforcement decisions, trying to determine what is out of just, if we're going to use ethics as one of the standards, or we're going to use competency, trying to determine how that is applied to the standards. So regardless of other standards, USPAP has been serving as the baseline, and until such changes come, that would be recommended. So what is the harm? The harm could be in public trust. It can be a result of confusion and inconsistency on the very people we try to serve. And that being the public we all represent and for the most part are sworn to uphold. There could be a perception of advocacy or bias depending upon how the standard is viewed and how it might be enforced. That must be avoided. And client setting standards, I'm not sure how much we're going to be able to buy into that with what we have now. States are all structured differently. You've heard mandatory. You've heard mandatory FRT and voluntary. The one thing I've found in those states, as I'm told by many of the state's attorneys and the attorneys general, it is that those states view licensing and certification somewhat different, but many of those states say you don't have to be licensed or certified to practice, but when you do become licensed or certified, then our laws, wherever that state may be, are binding upon your practice for all practice, for good or bad. That becomes the law. So I've heard it said that probably it would affect few. 90 to 95% of appraisal assignments that come into Kentucky are non-FRT that we look at. So within Title 11, there is another definition that we look at with FRT, and it's the real estate related financial transaction that ties the government agencies, Fannie, Freddie, even FHA, VA, and rural housing. So how many other standards might there be? It could be unlimited. I promote using other assignment conditions by whatever group wants those conditions, but it could be horrible to make it mandated in law. Thank you.
Thank you, Mr. Disney. Kenny, you next?
I thought you'd already been here.
He's speaking on a different issue this time.
Oh, okay.
You got 3 minutes.
Thank you, sir. Sorry, I didn't sign up. I'm now speaking to you as Danny Wiley, individual appraiser. I do have a fairly unique viewpoint on this, I believe, because I have served on the Appraisal Institute Standards Committee. I have served on the Appraisal Standards Board of the Appraisal Foundation, and I have served on the International Valuation Standards Committee Standards Board. I actually have a copy of those European standards that Mr. Coyle referenced earlier. One thing I would like, and Larry, Mr. Disney touched on this, but I think as you consider this, it's critical to understand that Mr. Coyle's comments, he used the terms federally related transaction and mortgage lending almost interchangeably as if they're synonyms, and they're certainly not. And as a commercial appraiser, it's probably not as big a deal to Mr. Coyle, but as a residential appraiser, it's critical to understand that the vast, vast majority of residential appraisals performed in this state are not federally related transactions, right? Many people do not realize that any appraisal that's done that is eligible, if the loan is eligible for sale to Fannie Mae or Freddie Mac, or is insured by FHA or VA, as stupid as this sounds, those are not, by definition, federally related transactions. So I was very uncomfortable with Mr. Coyle's presentation of using those terms synonymously, and I'm sure he didn't intend that. But when you look at the ramification that this might have on the residential world, I just want you to have that in mind, right? Again, I've been a member of I was a student member of the Society of Real Estate Appraisers since 1981. I have great respect for the Appraisal Institute and the Appraisal Foundation, but I think this is not the best idea they've ever come up with. For years and years, the Appraisal Institute actually had in their own code of ethics that one could follow the national standard and the IVS standard if you were not in the United States. So they recognized the layered standards. And I submit to you that the comment that Mr. Coyle made, with all due respect, that if Volkswagen needs an appraisal done by European standards, there's nothing that would prevent an appraiser from accepting that assignment and completing it both in compliance with USPAP and the European standards. So there should be no prohibition or nothing that would prohibit that business from coming into our state. So I appreciate your time. Thank you.
But, Mr. Button, you yielded your time. Do you want to use it now, or you're good? Okay, I think that concludes all the speakers. We're at this. Okay, I don't think you signed up, but I gave some latitude to Mr. Wiley. I'll give you some latitude as well. You have 3 minutes, sir. There was 2 lists, so you probably did sign one list and then, but go ahead, sir. Here.
I'm also here with many hats on. My name's William P. Wilson III. I have several hats I'm wearing today. I'm current chairman of the American Society of Appraisers Real Property Committee. The American Society of Appraisers is a multidisciplinary appraisal society that's over 75 years old. We have a lot of international members in business that we do. We're unique in that our members appraise stuff that is non-real property. And some of the non-real property is very valuable. To give you an example, an oil well rig in the Gulf that one of our machinery and technical equipment appraisers would appraise can be $40 to $50 million item. Our business valuation people value some high-priced things, like football teams, which Mr. Haslam has already established now is worth $1 billion. So we have members that do a lot of high-dollar appraisals, and a lot of them are international. All of our members follow Uniform Standards of Appraisal Practice. That's part of our code. So it's not an issue and not a problem. I agree with Mr. Wiley. I can go down to Chattanooga and appraise the Volkswagen plant, and I can do that in compliance with USPAP. I also come here with a hat as a fellow ex-commissioner of this board. I was on in the 90s when we first started. I can relate to you, we put a lot of hours in and a lot of days in. If you want to regress back to 2 and 3 day meetings, adopt this standards, adopt the standards from ASA, adopt the standards from farm managers or rural appraisers. McKissick will probably come out with their own set of standards and ask you to adopt theirs. If you want to do all of those, welcome back to the 80s. And guess what you're going to get? You're going to get long meetings, because the other hat that I have wear is was doing compliance reviews for this board as a compliance reviewer. We're doing those under uniform standards. If we now have to do them under the Appraisal Institute standards, somebody's going to have to get educated there and learn how to review a report that way. The person may come in and say, no, I'm meant to do the report under Appraisal Institute standards, not USPAP, so you can't run a complaint on me. So, or now we got the farm managers come in with their standards. How are you going to legislate this and review people that are not following the rules and not protecting the public trust if we've got half a dozen different standards that are being imposed upon this state? I think you really need to consider what the can of worms you're getting ready to open up here, because as we found in the 80s, when the genie came out of the bottle, it's not going back. We're not going back to the 80s. We can't go back to doing the letter appraisals where we drove out there and came back and wrote a letter and said your property's worth $100,000. Standards are good. Uniform USPAP standards are very flexible, what you can do. You can do multiple disciplines under it, which is something ASA members do a lot. We do a lot of teamwork. I just finished a hospital up with a business valuation appraiser, a machinery and technical equipment, and me doing the real estate. We all team together. One report goes out to the client. So, USPAP's got flexibility. So please consider what you're getting ready to do here, and thank you for your time. Good to see some of my friends on here.
Thank you, Mr. Wilson.
Yeah.
All right, Mr. Button. Okay, all right. You have 3 minutes, sir.
This is a group of has-been commissioners. I just want to follow up on something that Bill made a statement on. And yeah, we did spend a lot of time, but that was around experience and seeing who was qualified to be an appraiser when we were initially licensing and certified appraisers. I don't think there's anything today that you've heard in this proposal that would substitute for uniform standards appraisal experience. You still have that latitude as a commission to require that for preliminary experience to become licensed and certified. What's being proposed is appraisers in this state today, we have to operate in a box, in 4 walls, and that box is USPAP. There are many other services that we can provide with our expertise, our experience, and our knowledge that may operate outside that box. That's all that's being proposed here today, is allowing appraisers to use the tools they have in their toolbox to do something else that provides a meaningful service and answers a question for a client that may not be in that USPAP box. So this happens every day in things that we have to deal with, whether that's at the Department of Transportation, work that we do preliminary. We're now being asked as review appraisers to have an administrative function. That is being done outside of TDOT, where it's not being done with employees. Many times, local agencies, I know all of you are familiar with the LPA project. They are administering the federal and state funds. You go to the city of Franklin or the city of Bartlett or wherever across the state, they do not have the level of knowledge and expertise that TDOT has had over years. Many times, a review appraiser is engaged on the front end to identify what assignments are going to be administered by the appraisers. In that process also, TDOT for years have done PGIs, which are preliminary assessments of what the budgeting criteria is going to be for the acquisition of properties that are going to be affected by a project. Today, review appraisers are being asked to do that. They're not comfortable putting numbers on unless it's a USPAP appraisal, because we can't give a direction or a range or a single value unless it's conforming to USPAP and within the state law. So this is another area, as Mark spoke to earlier about USDA, also with the Department of Transportation, there are some latitudes that we could afford to our appraisers and allow them to do that work. Thank you.
Thank you, Mr. Button. All right, at this time, I'm going to open it up for the commission to ask questions regarding this proposal. We'll start to my left with Ms. Point and
Pass at the moment.
Okay.
Back. Let Norman go ahead. He's got 2 pages full.
Mr. Hall got 2 pages. You're on go, Mr. Hall.
It's on page 3. Okay. thank everyone for being here. Number one, I find it a little odd that y'all are here doing what you're doing, and we never knew about it. That was your decision, not ours, because we were never told what was going to be going on today when y'all were going to be here. I find that a little unusual, but that's your call, not ours. As far as USPAP is concerned, when Danny was last speaking, I know she left, but he said that over half, if I understood him correctly, and anybody can stop me and say you're wrong, but quite a few of the residential properties are not being made to conform with USPAP because they're not regulated. Or, am I correct in that, or did I misunderstand him?
No,
Anybody?
You misunderstood him. He said that the bulk of the mortgages out there being made are non-FRTs, non-federally related transactions by definition.
Okay, would that
But they're
imply?
still following USPAP.
But
at
they
this
would not
point.
be required to comply with USPAP, is that correct?
Currently, they're required to. Yes,
Currently, they were required to.
yes.
He was talking about residential in that
Right,
particular-
mortgage, secondary market loans, basically, to an extent,
Right.
are by definition non-FRTs.
Okay. Well, once again, I'm just trying to understand what he said, because that's not what I heard. But,
Could I quickly respond to that?
sir?
He's going to answer
Oh,
that.
go ahead.
I just wanted to clarify that any legislation that
Oh, go
we
ahead.
would propose would specifically preclude the use of any alternative standards in any type of mortgage lending transaction, whether it be FRT or non-FRT. We don't want to go into that space.
Okay, all right.
But once again, just so y'all will understand where I'm coming from. Hamilton back there, and I go back a few years. I became a member of the society as a designated member back in 1967. Came up into the American Institute back in 72, 74, got all these designations. Served on every program almost within that organization. So from 1964, from the time I came in, going back to 1932 when they got started, means that this organization for many years had been dealing with the public and with the mortgage lenders and other people. They are not a Johnny-come-lately. They did not develop their current reputation by having just came in 25 years ago. They've had many years to develop it. I personally do not like some of the things that I've been reading in USPAP, especially when I'm sitting on the stand and I have attorneys cross-examining me on items that are in there that I know are false. So I know these are wrong, bad information being printed in that publication that's coming out. All that being said, for whatever reason, and I don't know the answer, I don't know why a government agency, which was created back in 90, 89, 90, somewhere in that area, with Senator Dodd, who came up with a great idea that you got to let people borrow the money, whether they can afford it or not. How do you expect them to have houses? And then all of a sudden, oh, we're going to come up with a government agency that will tell people how they can get the numbers so we can make these loans. That's a problem, folks. That is not good economic knowledge. When this organizations got started, I say these organizations, I'm talking about the one that's the federal agency as well as the Appraisal Institute. They got started, they were working together. Why were they ever involved to begin with? Because they had been involved in the appraising profession at that point in time for many years. They were brought in because they had experience, they had education. Everybody knew about that education. No disrespect meant to any of the organizations who are providing education, but I've had people come to work for me who've taken these other classes and said, wait a minute, they're no good. So they've had to go back and take them as sponsored by the Appraisal Institute so they can learn what they're doing. So I have a concern. I've got a bigger concern when I get a email from the appraisal federal agency saying, oh, we're going to get into education now. No, it's my understanding they're not supposed to be in education. That's supposed to be done by local people. So consequently, I'm still trying to get my arms around why are we even here today talking about these things. Why did we ever get that far apart to begin with when the whole purpose was to try to come together and serve the American people to the best of our knowledge and the best we could, well, we could bring to that point to begin with, the education, the experience, and the knowledge. I don't have any answers. I just don't like the way things seem to be going because it appears to me we want to say we need to do this, we need to do that. There seems to be no meeting of the minds of the individuals, more or less, well, so-and-so supports me, they don't support me. That's not the way we need to operate. We all ought to be professionals and do what we can for each other. That's the whole idea, to help each other, not to try to say, I'm bigger than you are, I got more money than you got, and so therefore we're going to go my way. It sounds like a husband and wife getting a divorce. Unfortunately, I serve a lot of appraisals for divorces, and I hear a lot of this going on. I don't understand that either. If I hadn't been married 51 years, I'd probably still be single, but but I would like to suggest that the parties, let's say, look, guys, we both made mistakes. We both have tried to play big boy. We've tried to tear you down any way we can. Let's get together and say, hey, from here forward, let's decide what is good and move forward again rather than constantly coming out wanting to fight each other because we don't think that's the right idea. And believe you me, there's a lot of appraisals that are made where you do not have to file a USPAP, because I've never been able to file a USPAP yet because of some of the things they require. It doesn't make a bit of sense. But thank you so very much for indulging.
Thank you, Mr. Commissioner Hall. Commissioner Walton?
I'm not going to get up here and pretend that I can plumb the depths of both sides of the issues. I think there are valid points and there's merits on both sides. I think some of this may, in my opinion, and having been an appraiser for over 20 years, that the definition of an appraisal seems to be overly broad. You know, a range of value, up or down from a benchmark. I mean, you know, I think that's where a lot of this comes back to, and boxing appraisers in and making appraisers' licenses very limited for what we can do as professionals, and I think maybe instead of introducing and layering standards, we go in and we look at some of those type things and how we define an appraisal may be a good starting point. And that's my opinion.
Mr. Collinsworth?
I have a few questions or points, and it's sort of between every one of you that spoke today, possibly. I wish Mr. Wiley hadn't left yet. I guess the first question, Mr. Coyle, you could probably answer. You had mentioned California and Texas were in the process of changing some regulation. Can you elaborate a little? Are they in the process of approving this to some extent, or just opening up to allow for multiple different requirements? Or
Texas has already passed the law. It's been signed into law by the governor, so it's a done deal. In California, the law has been through a key House committee where it passed out of that committee. It's now in an appropriations spot, and they'll have their say, and then it will move on through the process. It's not law yet in California, but it's certainly
Discussing it.
It certainly looks
It's
like it's
moving through
making,
legislation.
it's making its way through. Yeah.
Okay. And you may be able to answer this. If not, maybe Mr. Bunting could. Are those two states mandatory, or I guess if Texas is passed, then maybe not, but were they previously mandatory, or were they two of the 17 that we're discussing?
Texas is a mandatory state. California is voluntary.
Okay. California is one of the hybrid states. I know she had mentioned that another state had never moved backwards, but I guess it sounds like maybe Texas has.
The deal in California is that you don't have to have a license to provide a real estate valuation. However,
Unless it's a federally related.
Unless it's a federally related transaction. However, once you do pull a credential, then you are bound by USPAP when providing any valuation service, regardless of whether it's FRT or not FRT.
Okay. My next question would have been for Mr. Wiley and Mr. Badger both, but I guess with Mr. Wiley being gone, in regards to what you're doing from your standpoint, or what Mr. Wiley was doing, could the client not still say this has to meet USPAP requirements? So Fannie Mae, Freddie Mac, FHA, even if Tennessee were to make a change, could the client not still say, in Tennessee, it's still got to be USPAP, or even nationwide, it's still going to have to be, you still have to meet USPAP requirements?
That certainly could be the case. Just like
I'm sorry, I'm not trying to interrupt. Do you mind coming to the microphone so we can get this on the, I'm sorry.
no worries.
So I see where you're saying there could be a problem if you say you've got to meet USPAP, but if something has a stricter standard than USPAP.
There's no guarantee that any other standard outside of USPAP would be something that's less than. And so it could be contrary, in a sense contradictory to USPAP. Then we would really have difficulties of saying internally we would wish somebody to abide by USPAP, but yet under state law, if this were to come to fruition, could require something different than. And since we don't know specifically which standard we're referring to in this discussion, other than the one that's proposed, that is my greatest concern of where this will end and what could manifest out of something like this.
May I?
Sure. Yes, sir.
Except that we don't, this model legislation doesn't even apply. Mr. Badger is left out of this situation. Nothing will change for him. Nothing. Zero. Nada. It will stay the same. Let me reiterate, nothing will change.
Right, from your position that you have right now. However, from your investigatory work that you do, is that always in line with your main position, or would that be, do you do investigatory work through the states for divorce cases, for those type cases as well that may not be USPAP?
So yes,
I want to sit there for just a minute.
That's okay, sure. So again, we don't know exactly where this would end outside of lending. I know that what you're explaining here is for lending purposes, my understanding it would still require USPAP compliance, correct? Yes. So then outside of lending purposes, if it was a requirement on a state license or certified appraiser, then that could still be a matter before your board and a difficulty for investigators to follow yet additional layers.
At that point, would this be a scope of work factor as to between the client and the appraiser, which, go ahead.
The client, let's say you have an appraiser that's doing an eminent domain case where, and maybe they're working for the landowner. If they choose to follow an alternate set of standards and the client agrees, they could do that, and they'd have to disclose that. And that set of standards would be available to you guys. You would have had to have approved it ahead of time.
Right.
You. Now, If that client says, Mr. Appraiser, I want you to comply with USPAP, then you would comply with USPAP. The point is that it gives the client and the appraiser an option if they choose to use it, but it does not in any way set up a requirement of any kind. If you want to use USPAP in a non-lending, non-FRT situation, maybe you're doing valuation for financial reporting or you're doing a tax appeal, or if you want to do that, it's optional.
Mr. Chair, can I just add one point? I couldn't help but observe this morning when you had 12 cases that came before you. 11 out of the 12 were residential, 1 was commercial, and I believe, not having all the information in front of me, every single one of them was an FRT. The point that I'm trying to make is that non-FRT complaints that come before this board are few and far between. So even if a transaction, an appraisal was being done according to an alternate standard of valuation practice, the likelihood that it would come before this board for enforcement purposes is extremely slim.
Well, and I guess that's going to be a good segue into my next question between the two of you. How many types of standards are we talking about? You mentioned international standards, European standards, Japanese standards, Red Book. Are we talking 10 or are we talking 40?
Up to you. If you want to approve 1 alternate standard, that's your call. If you want to approve 5, that's your call.
Well, then that leads me back to, and again, I haven't had the chance to read the entire letter, but the Appraisal Foundation, International Valuation Standard Council, and the Appraisal Foundation collaborate to bring greater consistency to appraisal standards. Is this not something that they're already, this seems to me like they're trying to at least get an additional standard recognized over and above USPAP with the international valuation standards.
My understanding is that Foundation and IVSC have been working together over some years now to try to find commonalities between the 2 different standards. They have not come to a resolution of that yet.
That's kind of what I'm getting from all these quotes.
I will tell you that I was in a meeting with IVSC leadership Friday. I was in a meeting with them and 9 North American real estate appraisal organizations, not real estate, but 9 North American organizations. And at the end of that meeting on Friday, it was widely accepted and decided by the IVSC that 1 valuation standard applicable to every kind of transaction out there was not the way to go. This is a significant departure from what the IVSC has been saying, and today they are, in fact, nearly agreeing with what we're saying, is that different standards can work really well for different situations.
If you'd like to elaborate.
Can you respond to?
No.
Sure. A couple things. One, the IVSC and the foundation have been working together. We met as recently as in May, and we've agreed to have a bridge document that when you follow that, you're going to be able to comply both with USPAP and IVS. We signed a memorandum of understanding with them last fall. They say that in the United States, the valuation standard of record is USPAP. Now, what they said last Friday, I wasn't at that meeting, but I've met privately with the chairman of IVSC several times. What he's talking about is he doesn't want to have to reinvent the wheel. If there are European standards and Canadian standards, let's cherry pick from existing ones as opposed to starting with a clean piece of paper. That's what he's talking about. But they want to have a common set of valuation standards around the world. The United States is a little bit different because of the federal law regarding USPAP. If there's a lot of words spoken today, words to remember, I think. The juice isn't worth the squeeze. There would be an awful lot of trouble here to go through all this, the administrative burden and everything, for very little difference. We haven't needed it for a quarter of a century. No other state has done it. The language in Texas says must be substantially equivalent to USPAP. When you talk to the board members, they say, if it's substantially equivalent to USPAP, why bother? Just use USPAP. So, thank you.
Well, and that leads me to my next point, and then I'll have one more point after that. And that point is, I wish we would have, if Texas has already signed it into law, I wish we would have been given a copy of that, maybe to look at to see
It's a reauthorization
What
of the board. You know, they have a sunset provision. It's just one sentence.
Okay.
It just says USPAP or something that the board deems to be substantially equivalent to USPAP. If the board doesn't want to take any action on it, then USPAP is the only standard there.
Substantially equivalent?
Substantially equivalent, yes, sir.
Well, and that leads me to my last point or question. I think this is probably going to go back to Mr. Coyle. You had mentioned that the federal law basically was regarding FRTs, and you said that Tennessee is more strict than the federal law right now. Can you elaborate on that a little bit more?
Well, yeah, we're just saying that Tennessee law requires all appraisers and appraisals to be completed in compliance with USPAP, whereas federal law
says for FRTs only.
Tennessee law says that the state law will not be greater than the federal law. And the federal law was all about lending and FRTs. It was not about this other stuff. So the fact that you're requiring that
therefore greater than the federal
is
law.
Greater than the federal law.
Okay. That sums up my questions and comments. I appreciate it. Thank you. I just want to thank everybody for being here today to be able to speak as well as you have on it.
Dr. McCara?
Well, first of all, I want to, in complete disclosure, I am an economist. I'm not a real estate expert, an appraiser, or anything like that. So the comments that I make, the questions that I ask, please keep that in mind because they may be really stupid ones, okay? On the other hand, I'm a classroom instructor, and I try to tell my students there is no such thing as a stupid question, okay? So bear with me on that. I want to congratulate both sides of this matter by presenting very cogent points of view. I found it educational, and I think both of you have presented arguments very much that, you know, either one would have been convincing to me. It was interesting to hear them in contrast. I think that it is important that we understand that an international presence is certainly nothing that is on the wane. We're only going to see more and more things that involve international types of issues, and that becomes a problem. I also like the point of view that the other side made about the challenge that this creates to the expertise of any commission with all sorts of different rules and regulations, et cetera, that it could create some real legal issues about whether these things were adjudicated with the proper set of knowledge. So that makes me a little, makes it seem like more of a problem. The other thing I'm concerned about is a slippery slope that this might create. As you said, all lending types of appraisals would be still under USPAP. But I'm wondering if that's something that, you know, it's like the camel getting its nose under the tent. Okay, once we open it up here, could that spread to other things? Well, that's what we said before, but now we can see that there are other issues where maybe we don't want to use USPAP for even all lending types of operations. I'm also wondering if this is going to create the possibility that when we're dealing with international things that cross state boundaries, whether that would create an increasing irrelevance of state commissions, which would mean, like so many other things, it gets kicked upstairs to the federal government, and then we have more federal intervention into this. Again, those things might be totally paranoid fears that I have, but those are some of the issues that came to mind as I heard the arguments on both sides.
Thank you, Dr. McCara. Commissioner Thomas? Wait, I'm sorry. Do you have a question?
I'm just going to respond to one of the doctor's comments. I think you and I are the only two people from New Jersey, by the way, in the room.
Oh, okay.
But,
what part of New Jersey? What exit?
Monmouth County, exit 8.
Oh, okay. I'm at the other end of the state.
Okay. But one thing that was sort of alluded to here is the day that you have the authority to start approving other sets of standards, you're going to have board meetings with more people in it than this one because they're all going to be in line to get it approved.
Yes, could you please come to the, and if you've already spoken, please leave these seats open in case we need somebody else.
Dr. McCara, I think you make a great point about are you opening Pandora's box here. But what you have to understand from the lending community is we already have a provision in the state of Tennessee called an evaluation that's in our state law. So under lending now, today, that there are loans being made without appraisals that fall under the evaluation statute. Also, the de minimis level is something that's debated often among the regulators. And there is talk about raising that de minimis level from $250,000 to $1 million on residential properties. So in that case, you would still have issues where that there are lending decisions being made that fall outside the scope of USPAP here in our state. So I don't know that we're really opening Pandora's box on that, because we have been we've been very definitive that any type of mortgage lending transactions would still fall under the auspice of USPAP. We're only talking about a very small subset of work, and it's going to be up to you as the commission to make the determination on what alternative valuation standards that you approve. They would have to meet a criteria that you establish. You may only approve one, you may approve two, you may approve none. That would still be under your auspice as the regulatory body to make that decision. We're sitting here talking about something all day today. It's an information gathering exercise, but it's going to be inherent upon the state legislature to make the decision on whether this is something that would be allowable. But I understand you are the ones that would have to administer and regulate it. But it's still up to you on which alternative valuation standards that you would find appropriate that would meet your standard of practice.
Thank you, Mr. Button.
The education, thank you.
Commissioner Thomas, any questions?
I have a question for Mr. Coyle, I guess. Because I am a practicing appraiser, and I'm always hesitant when we see these complaints come through on appraisers, because I have to constantly remind myself that this commission is here for the public trust. Can I safely assume that in the prepared statement that you had, you probably had some sort of brain trust to help you put that together?
Actually, this is the brain trust right here.
Well, but my question, I guess, is this. Ms. Hamilton spoke for 3 minutes. Mr. Bunton, Dave Bunton, spoke for 3 minutes. Mr. Disney spoke for 3 minutes, and Mr. Wilson spoke for 3 minutes. And in those 3 minutes of all those people, each one of them spoke multiple times about the public trust. And in your 15-minute talk, you never mentioned the public trust. Is that deliberate?
No, but I'm actually glad that you asked that question.
I know, because I'm going to feed you when you go to Virginia to come up with theirs. I realize that, but I'm just kind of curious.
They did mention the public trust, and I have to say that the idea that the Appraisal Institute does not protect the public trust has no connection to reality whatsoever. Public trust, confidence in the appraisal profession are utmost in our minds at all times, always have been. We have a decades-old record of advocating for the profession and advocating for what's right for the public trust.
I appreciate that, except for the fact that I love my wife, but if I waited years to tell her that, she might be loving somebody else.
We speak about it all the time.
I think I would just add that there are many cases where we take disciplinary action against one of our own members when a state board does not take disciplinary action. So in some cases, we're taking action that is more stringent than what some states do.
Thank you.
May I have an opportunity also?
Yes, after I finish mine, since we can take the commission first. Well, I'll tell you what, you go, and then I'll wrap up with my question.
You forgot this lady, you forgot this lady.
I thought, okay, you're back on board. All right, let's go. Ms. Ford.
I deferred for him. He had
Okay,
so many questions here.
Okay, Ms. Point, you're recognized.
This is a question for Mr. Bunton, please.
Mr. Bunton, can you please come back up?
I have a question for you. How difficult would it be to intertwine all of the various ideas presented here together into USPAP? What would it take to incorporate some of this into USPAP?
Maggie Hamilton is the vice chair of the board. I think she'd be better to answer that. But, I mean, some of the things that are contained, for instance, in the Institute's standards about contingent fees, no record-keeping requirement. From an enforcement point of view, there would be no work file. I don't know how you say USPAP requires a work file, they don't require a work file. How do you split the difference on something like that? This, correct? So.
Yes, I would encourage you as a commission to take a look at AIs for an example, because the principles based, and most of the principles have some portion of the USPAP in them. It just doesn't have the steps underneath. So you've got a principle, and it's what I started to say. You have a principle, but you have nothing that would let that principle be enforced. So somebody could say, well, I did it in concept, but you wouldn't have, and I'm trying to find the part about the differences. A principle, unless you have requirements or prohibitions as part of that principle, you have no way to see if somebody complied with it or not. And that's an issue. And in the AI standards that came out in January of 2015, there is no record keeping. Record keeping, as we know from serving on the commission or serving on a state board, is of paramount importance because it follows what the appraiser did to support and to document their work file. And without that, you lack one piece of knowledge that you need. The other issue that when you came there, when you look at this, is that their principles in their reporting doesn't ask, unless there's other subsets there that didn't show up in the standards, but it says state your opinions and your conclusions and state the documents that you used, but there's nowhere in there that says support your adjustments, support your conclusions, support your assignment results. And as a practicing appraiser, I know what I want to say in a report, and sometimes I miss some of it, and USPAP provides me with kind of a clear set of steps that I can say, okay, I've covered this. And they mentioned a checklist. Checklists aren't all bad for us appraisers to make sure that we're still continuing to work efficiently. So I would just encourage you to actually take a look. You're going to see a lot of similarities without what I like to call, you're getting the appetizer, but you're not getting the meat.
So they can't be incorporated. Is that what you're saying?
I'm saying parts of them already are. That's what we're saying. They've taken the document and they've reduced it down substantially, that it lacks the bite. It lacks the steps. It lacks, USPAP we say is minimum. I don't know how you can do less than minimum and still be an effective appraiser. And so that's why I would really encourage you to look at these and look at them in relation to USPAP and then draw your own conclusions.
For enforcement purposes, to have an absence of rules, people say, I understand the principle. Okay, now just tell me what the rules are. There aren't any rules, and that's what makes it very difficult from an enforcement perspective, because there's just an awful lot of latitude out there. It's not black and white, it's all gray, which is going to cause a lot of consistency problems when you're out there enforcing. You can't point to a line that says you violated 2-1F or something, because it's a little bit amorphous. Yeah.
Rebuttal to that?
Well, if you look, first of all, what we're talking about here, what we're suggesting for Tennessee legislation is not AI standards. So to attack the AI standards right now, I think is a little off topic, because you guys will decide what standards you want to accept and which ones you won't. If we end up with a change in the law and the AI comes to you and says, would you take a look at this? You'll take a look at it and you'll make a judgment about what's required, what's not required. But if you carefully read the document that we have, those principles of ethics and competency and impartiality are all in there. They're just not laid out in a and a lot of different rules, but they're all there, all the same things that an appraiser would have to do to have their work credible and believable, impartial, all the things that we cherish. They're all there, and they would all be required.
I'm a little confused by your answer. It seems like you didn't really answer it.
Are you asking a question, or are you making your
I'm
statement?
I'd like to ask you to specifically answer, because no other group has come to Tennessee asking about possibly changing professional standards other than Appraisal Institute. So what are the record-keeping requirements included with AI's professional standards?
I appreciate the question. I think it's a little premature here because we're talking about high-level legislation that would allow you guys to pick and evaluate standards that you want to look at. To get into a debate over specifics of standards today, I think is a little premature. I will tell you, though, that the sky is not falling here. Everything will be okay if you guys do this. It's not going to be a significant administrative burden. It's not going to be significant cost. It's not going to be confusion. There's not going to be disaster. The sky's not going to fall. Whatever standards you guys look at, whatever you approve will be approved by you. And if the day comes when that's the case, then you'll have an opportunity to do that.
But also, does the AI's standards include for payment of being appraisers being paid by contingency?
Mr. Chair, if we could just bring this back in,
yeah, let's try
commission
to
members
corral
only,
this
not
back. I
staff.
want to make a statement here. The whole discussion is not about any one particular organization's group or rules. It's about just having other options out there. So these questions specific to, you've got several different types of valuation standards out there. We're talking about just options, not specific, this one or that one.
Well,
So if we can hone that
If Tennessee
into stuff.
adopts it, though, then we would have to make allowances in this, potentially make allowances for an appraiser to comply with that. And part of those, the whole of the standards are in the ethics rule, not accepting payment by contingency, or maintaining records for 5 years or 2 years past litigation. And those are things that are very important.
I don't disagree with that, but those questions, I think that's a little premature at this time. And that kind of parlays into some of my questions I have about Texas when I choose to speak in a minute. But those questions would all come out when you're evaluating that particular set of standards. When one person or one organization brings their standards to this body, it may or may not have those items in it. And then that would certainly be the time, I would think, that you would scrutinize those.
They didn't answer even one of the questions. So, it seems a little unfair to come here, ask about professional standards, and not even answer one of the questions.
I'm at a loss. What do you mean, a payment contingency? What are you talking about?
Like, if you come in over $1 million, I'm going to pay you $1,000 more than.
Contingent fees.
I'm sorry. I'm just a poor.
You get paid $500 if it comes in under $1 million. You get paid $1,000 if it comes in over $1 million.
Most appraisers that I know of are very ethical people.
Right.
And I personally, this is just completely out of left field, a foreign language for me. When you start talking about contingency, you're going to have to come up with this amount in order to make this much money. I don't understand that at all. When I do work for clients, I did recently one time on an assessment. I never did tell the guy a fee. I said, this is what happened. This is what your appraisal was. This is what it now is. You pay me whatever you want to. I'm not even going to quote you a fee. He did. I just don't understand all these questions. I'm sorry. I don't understand where you're coming from.
May I?
Mr. Cole, yes, you're recognized.
Just real quick. If you follow the ethics rules under most major types of standards, you can't be biased, whether you accept a contingency or not. Now, we've heard about IVS today. The International Valuation Standards allow contingency fees. And in Tennessee law, your Attorney General has already ruled that contingency fees are okay under special services.
Savers, do you have any other
I don't
questions?
think that's true.
Did
But-
you have any other questions?
No.
Or comments? Okay.
Since I brought this up, may I just wrap up with just one statement?
Yes.
Okay. I would just, the reason that I compared it to AI was this document that you received that references them in relation to USPAP. We didn't get a chance to get into all the errors in here in relation to USPAP, but they do make a specific comparison, and so I was responding in kind. So I just want you, and I believe I said if you look at any standards, make the comparison between what's similar and what is not. So.
Thank you.
Thank you.
All right, I had several observations and basically one question. But, and I appreciate everyone that was here today, all the various organizations that traveled in from out of state. Thank you for that. Thank you for your travel and thank you for being here. And I also appreciate everyone here locally and the local appraisers that were here and brought forth some information that was very important and valuable to me. And I thought, from an observation standpoint, I found it very interesting that our own local Tennessee Appraisers Coalition is open to more options and flexible things at looking at how we can help this industry. So I thought that was refreshing to hear from Mr. Button that our local folks are looking for more options. And then cited two separate examples from local agencies with USDA and Mr. Hedden indicating their need for other options and other, at times, was interesting, as well as with TDOT and the PGIs and those type things. So all of there is a need, it seems, here locally within the state of Tennessee for some other options, or at least being able to have some concrete ways that you can tie back to USPAP that doesn't bind the hands and scare the dickens out of the appraisers out there that say, well, I don't want that assignment. So I do think those are some things that are very important. I also think that from what I understand, with what Texas has already done, they added one sentence in there that said something, a standard that's other standard besides or something equivalent to USPAP. I don't remember the exact wording. But my question is, has the state of Texas approved any other standards at this point? They just have that option within the law, but have they approved another set of guidelines?
The law doesn't go into effect until January 1st of 2016.
2016, okay. Okay, so with that being said, that was my question. When have they? And the answer would be no, and they won't until 2016. But certainly, Texas has always been a leader, and the state of Tennessee is closely akin to Texas. And we were down there helping them with Davy Crockett years ago. And my point in that is they've always been a leader, and they've always been a defender of states' rights. And this is a states' rights issue, which some of the folks have brought up here that are on both sides of the coin. So, obviously this is not something that we're going to make a decision and vote on as a board today, but I do think it's something that we need to start paying close attention to and looking at ways to move the ball forward. Also looking at ways for both parties that are pro and con of other standards to possibly talk and work together, because at the end of the day, the appraisers, we're just a small group of folks out here. We have no bite when it comes to our presence with affecting legislations across the country. Even in Arrow, that several of us were there a couple of weeks ago. We've got to learn, as I'll come in with Ms. Point, to try to find ways that we can, find some common ground on, but also when you've got a state like Texas that's already approved it, I'm sure they're going to be approving something in 2016, and I think we can take a hard look at that and say, does that make sense for the great state of Tennessee? That's all the comments I have. Any other wrap-up comments? And I appreciate everybody being diplomatic in moving through. And also, everyone got more than enough time because nobody was 3 minutes except Randy Button, who went under 3 minutes. Everybody else got well more than 3 minutes.
I have one wrap-up comment. The board of directors of Aero did have a discussion about this, and including Texas was on the phone, and Texas was the only state that was in support of that alternate standards. And so when Aero drafted the letter, no one was against the Appraisal Institute. I want to make that very clear. No one. Appraisal Institute is really unsurpassed at delivering education and is a very valuable part of Aero. That's not a question. But the thought of having different professional standards was not supported by the regulators that were part of the board of directors. And it could be the first step in shutting down reciprocity amongst states. So that's something that really, Dodd-Frank set up reciprocity amongst all the states. And that was a big fix that Dodd-Frank actually brought to the table, is reciprocity. It was like a first big good thing. At least I viewed it as a good thing. Finally, all states had to get along. And if we have the states coming apart over something like differing professional standards and not agreeing that everyone's playing by the same rule books, then that could be the first step in going, well, Texas and California and Tennessee go by this rule book, and Ohio and Kentucky go by that rule book. And I really think that's dangerous territory to start thinking towards. I'm certainly willing, and I'm certainly, whatever the will of legislature or the will of the board is how it will be enforced. But I really think that you need to give this a lot of thought before walking down that road, because I think the other states will be looking at us for leadership. And that's one of the reasons why I invited so many people here today to be part of this discussion.
Thank you for those comments. We're getting ready to wrap it up here. So, you do. You got 30 seconds left. And then we'll let Mr. Coyle wrap up.
I get to move Dave Button out of his seat. Okay, just real quick on reciprocity. Reciprocity is based on one thing. That's experience. To make sure that everyone is qualified in those states to act in Tennessee. We're not saying anything here today about qualifying experience to become a licensed or certified appraiser. That is uniform. It's called the Uniform Standards Professional Appraisal Practice. We're not trying to circumvent that. What we're saying is the people that are already licensed and certified, do not make them have to adhere to USPAP when it's not advantageous to their client or their practice or the property type they're looking at in a particular situation. So reciprocity is not an issue, I don't think, between states, because everyone has qualifying education. You will still have the qualifying education being it had to follow USPAP to qualify to be a licensed or certified appraiser. So the reciprocity issue, I just want to make that comment on that.
Thank you, Mr. Button. And in closing, Mr. Coyle? Yeah.
Thank you very much. I just want to say thank you again for having us here and listening to these issues and having a productive discussion. Folks, since 2007, the United States appraisal profession has lost 20,000 appraisers. We're down 20%. It's a huge decline. There's a lot of complicated reasons for why that is. Some of it has to do with age. A lot of folks are older and they're retiring. Some of it has to do with the fact that nobody new is coming into this business, and that's a whole nother problem because a lot of people are being discouraged from coming into this business. Some of it has to do with the business model of practicing appraisers, which has changed for many of those folks over the years. With the advent of AMCs, other things that have taken place in our business, it's become very difficult economically for a lot of folks in their lives, in their daily lives as a practicing appraiser to make it. And another thing that's happened is that we've had regulation after regulation after regulation piled on top of this industry for years now. It's complicated today, and it's dysfunctional, and it discourages folks from coming in. We've got to do something here because this profession can't keep losing people at that rate, or we're in big trouble. Deals are not going to get done. Loans are not going to get made. Fees will go up. A lot of practicing appraisers will love that, but the bankers, the realtors won't like it. Turn times will get longer. It's going to be really, really hard if we can't start bringing new folks into this business, and we're in some trouble here. We need to think about alternates to try to make this a little bit better for some folks. We need to allow appraisers out of that box that Mr. Button talked about so that they can pursue other business opportunities and make this business, make this profession attractive for people again. We should not forget that all those people have left this business, and we've got to do something to turn that around. And I suggest to you that considering just this one small change, which is not going to have this huge effect, it's not going to make the sky fall, one small little change might be helpful to some practitioners out there who are trying to expand their business services and trying to make it in the appraisal profession. It would be a very positive development in my view. Thank you again.
And thank you, Mr. Coyle. The one thing I'll say in my wrap-up statement on this is, if the sky is falling January of 2016 after Texas approves one, we'll see real quick whether it's going to be the end of the world or not. So that's within about 6 months from now. So we'll see whether or not everybody's predictions comes true on whether it's good, bad, or we don't know. So with that being said, I'm going to get ready to make a motion for adjournment, but I do want to take a amount of personal privilege and say I appreciate the opportunity to serve this body as chairman for the last year. I thank you for the opportunity and for the high honor of that, and look forward to passing the chair over to Commissioner Walton next month and Commissioner Standiford. Thank you all. At this time, do I hear a motion for adjournment?
I so move.
Commissioner
I'll
Point,
second.
seconded by Commissioner Collinsworth. All in favor signify by saying aye.
Aye.
Any opposed? We stand adjourned.